Yes.
Yes, we make this year of the talk about information identification.
33.
I pray that this meeting will come up after a week
That means next week.
next week.
What is this matter about?
Related to regularization.
Regularization. Next week, will it be ready? Okay. Mr. Mohan, Senior Government Advocate. Who is for the petitioner? Whether Santiago. No one from Santiago.
No, I've taken the concern of the other.
Okay. Lana Senior Government Advocate, with the consent of the Lana Council for the petitioner, prays for listing this matter after a week. Stop. The prayer allowed. List this matter after a week. Okay.
Like to mention item 28.
28.
Yes, Lordship. Yeah, I have received information that respondent, the sole respondent has expired.
Oh,
So I have been informed to make necessary application for implement of the legal years.
This is, what is this letter?
Yes, sir, this is an order also written by the.
Implement of the legal
Implement
heirs.
of the legal case.
Okay. Okay. Mr. Yangarpati, Land Counsel for the petitioner submits that he has received an information that the respondent,
Yes, the sole respondent.
the sole respondent, is no more since deceased, and therefore he has been instructed to implement the legal heirs of the sole respondent in the instant case stuff. And accordingly pray for
3 weeks time, Lordship.
filing necessary application in this regard. Stop. The prayer is allowed. List this matter after 3 weeks.
My lord.
Okay.
Require-
Keep it in the record.
Yes, Your Lordship.
Yes.
I beg to mention item number 24, 25, 26, and 27 of Part 2, Lordship. Lordship, the counsel for respondent number 7, Mr. N. Mujur, has expressed his difficulty in taking up the matter today, which has been consented by the parties as the Lordship. So let the matter be come up on Thursday as a fixed item number 1.
Thursday,
Lordship,
this Thursday.
Lordship, Lordship.
Okay. You are for the
Petitioner.
petitioner. On the joint prayer. Can we say joint prayer?
Lordship, Lordship. I've taken the consent of the petitioner as well. Lordship.
Okay. Okay, Ms. Apila Sankam, Land Counsel for the respondent number 7. You are for 7?
Actually, no, I am for
Respondent.
respondent number 6.
Okay. Respondent 6.
I'm mentioning
the
on
counsel?
behalf of respondent number 7, Lord.
Okay. Mentioning on behalf of the respondent number 7, submits that the Land Counsel for the respondent number 7 has some difficulties today and therefore prays for a request for me fixing this matter on Thursday.
Thursday,
To which the
item
Land
number
Counsel for the
1.
petitioner has no objection. Prayer allowed. List this matter on Thursday. Okay.
Obliged, Lordship.
Lordship, there's an intern.
Okay. The interim order passed earlier shall continue to then. Okay.
May I please,
Mr. Lord,
Yes.
Lordship, I beg to mention item number 14. Item 14, my lord.
Yes.
Lordship, in this matter, I'm here to receive.
Counsel not yet filed.
Yes, your lordship. If 3 weeks time can kindly be granted, my lord.
Hmm?
3 weeks time may kindly be granted, my lord.
Okay. Mr. Rangam. Okay. Land Counsel for the state respondent submits that he is yet to receive an instruction in the matter. Therefore, pray for further 3 weeks' time. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks.
I'm deeply obliged. my lord.
Okay.
May I please, your Lordship?
Yes.
I beg to mention item number 5, Lordship. I am for respondent number 4, private respondent. I may be allowed 3 weeks' time to file my affidavit in opposition, Lordship.
Whether the petitioner is present. Okay. You are Miss
Rebecca.
Land Counsel for the petitioner is present. Stop. Miss Apila Sankam. Land Counsel appearing on behalf of respondent number 4.
4, Lordship.
You have not received instruction.
Lordship.
Okay. Submits that she is yet to receive instruction to file affidavit in opposition. Accordingly, pray. Therefore, pray for further 3
3
weeks
weeks, Lordship.
time to obtain necessary instruction and to file affidavit. Prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Obliged, Lordship.
please, your Lordship. Lordship, I beg to mention item number 35 of the hearing this one. Lordship, here, we have recently entered appearance as the counsel for the appellant, my lord. So if may be granted some time to prepare. my
So
lord.
appear.
After 4 weeks, my lord, I have taken the consent of the opposite parties. my lord.
Okay. Miss Lucina, Land Counsel submits that they have just entered appearance on behalf of the appellant in the matter. And you require some time.
Yes, my lord, to prepare, my lord, since we have
Okay.
recently
And-
entered.
And hence she requires some time to prepare the case. Therefore, pray for adjournment of the matter for
4 weeks, my lord.
4 weeks. She has also submitted that she has obtained a consent from the Land Council on behalf of the Land Council for the respondents. Is prayed for, list this matter after 4 weeks.
Obliged.
May I please, Your Lordship?
Yes.
I would like to mention item number 17. We've already filed our Wakalatnama, so kindly grant us 3 weeks to file our affidavit in opposition.
So who is for the petitioner? Have you informed? Yes. Okay, you are Mr.
Shubha, on behalf.
Land Council for the petitioner is present. Miss,
Kuplisu.
your name is there.
Yes.
Item 17. Item 17.
Yes, yes, Lordship.
Your name is there.
No, I'm here on behalf of Zejimomi. Her
Okay.
name is not reflected in the cost list.
Okay. Miss so-and-so. Appearing on behalf of Mr. Judge Jimomi, Land Council for the respondent. Respondent number
4.
4. Praise for submits that you have entered appearance recently.
Yes. Lordship.
Okay. Submit that they have entered appearance in the case on behalf of the respondent number 4 recently, and therefore she needs some time to go through the matter and to file affidavit, for which she prays for. How much time? 3 weeks time. The prayer not objected. Accordingly, the prayer is allowed. Please this matter after 4 weeks.
Worship, there's an interim.
Stop. Para. The interim order passed earlier shall continue till the next date. Okay.
Obliged, Lord.
Yeah, please, Your Lordship.
Yes.
I beg to mention item number 18. My lord, the service report upon respondent number 5 is still awaited. So if this matter can be listed after 2 weeks.
You are for the petitioner,
18. Yes, my lord.
and an opposite party has not yet filed affidavit also. The other service upon respondent number what?
5, 5.
5.
Yes, it's still awaited.
Okay. Miss, you are Miss.
Sereni.
Your name is
Sureni.
Sureni Mozui, Land Council for the petitioner. He is present. The service upon the respondent number 5. Service of notice upon the respondent number 5 is still awaited. In view of the above, list this matter after
2 weeks.
2 weeks.
My lord, there is an interim order.
Para. The interim order passed earlier shall continue till the next date. Okay.
Much obliged.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 32 on behalf of Indian National Security, Lordship. If this matter can be listed after 2 weeks. 32.
Have you informed the?
Yes, Lordship, I have taken the complaint.
Okay. Ms. Chang, Land Government Advocate, appearing on behalf of the state respondent with the consent of the Land Council for the petitioner, prays for listing this matter after
2 weeks, Lordship.
2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Lordship, I also beg to mention item number 6, Lordship, on behalf of my colleague, Lordship. If 3 weeks time will be granted to me, Lordship.
Counter not filed, not yet filed.
Not yet filed, Lordship.
How much time you said?
3 weeks, Lordship.
Okay. You are Miss. Your name is there?
No, sir. No,
Hmm?
Lordship. No.
Miss?
Anyam kunyap. Miss? Anyam kunyap. Okay.
Okay. He is present on behalf of L. Likhase Sanktam, Land Council for the petitioner staff. Ms. Cheng, Land Government Advocate. Prays for. Submits that she is yet to receive instruction in this matter, in the matter. And therefore pray for further 3 weeks time to obtain instruction and to file affidavit. The prayer not objected. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Lordship. Lordship, I have similar prayer for item 7, Lordship, on behalf of IME, Lordship. If 2 weeks time will be granted to me, Lordship. Item 7.
Who is for the petitioner? 7 is, I think, is scale of pay. I think this similar order can be passed here, it appears. Can you just see, wait for some time, if it is a similar matter?
Lordship, if sometime may be granted to me, Lordship.
No,
we
no,
do.
you see, you have already notified, the government has, let us see, wait for some time,
Lordship.
okay?
May I please, Your Lordship?
Yes,
I take to mention item number, hearing item number 30 and 31. The counsel for a petitioner is on leave, so let the matter be come up after 2 weeks. Item number 30 and 31.
is there any private respondent?
Lordship, I'm appearing for respondent number 6 and 21 in item number 31.
Okay, no objection,
No objection, Lordship.
okay, how much time you said,
2 weeks, Your Lordship.
Mister?
I'm
You are-
appearing for my.
You are Mister, your good name?
Manum.
Appearing on behalf of Mr. Supongwa Tiwali, Line Counsel for the petitioner. Praise for submiss. What is your reason for adjournment, you said?
The counsel for the petitioner is on leave.
Okay, submiss that the leading counsel for the petitioner is on leave and therefore prays for adjournment of the matter for 3 weeks. To which the Line Counsel for the respondent has no objection. Accordingly, the prayer is allowed. List this matter after 3 weeks. Okay.
Please, Lordship.
May I please, Lordship,
Yes.
I beg to mention item number 15.
Yes.
Lordship, we have served the notice
Service report is still awaited.
to the respondent number 2 and 3,
Hmm.
and then service report is yet to receive.
Yes.
And therefore,
Mr. You are Mr.
Riley,
Line Counsel for the petitioner is present. Stop. The service of notice upon the respondent number 2 and 3 is still awaited. In view of the above, please this matter after 2 weeks.
2 weeks.
Okay.
2 weeks.
Yes. Okay.
That is the Lordship. Lordship, I beg to mention item number 19, Lordship. Here I'm for respondent number 1, Lordship. I'm yet to receive instruction, Lordship, may please grant another 3 weeks time.
So you received notice through Dusty.
Lordship,
It
no,
was-
I'm
it was for
appearing
the
for
government.
respondent. Yes, I'm for R1,
Arwan.
Lordship.
And what about the other respondent? Can we just wait and see? Because probably with the petitioner has taken Dusty service upon the private respondent. Let us see the record and. Okay. Yes.
May I please, Lordship?
Yes.
Your Lordship, I beg to mention item 10, 11, and 2 of your Lordship. In this matter, I'm for the respondent in the IA. Well, yet to file our affidavit in the police.
Yes. Yes.
So 2 weeks time will be done. 10 and 11, your apologies.
I'm appearing here for the appellant.
Not to notate file.
Yes,
Yes.
For the
Mr.
claimant.
For the petition applicant.
I'm for the claimant. Is for the petition. The
Claimant.
applicant is appearing to the BC. I'm for the claimant respondent's Lordship
In the IA.
in the IA.
Both the eyes.
Where from this sound is coming?
Lordship.
Okay. The IA is for?
For adducing additional evidence, Lordship.
Okay. Mr. Sidi Romsam, Line Counsel for the applicant is present. Stop. Mr.
Zakun.
Line Counsel for the opposite party prays for the 2 weeks time
Yes.
to file objection to the objection. Stop. The prayer is allowed. List this matter after 2 weeks.
Much obliged.
Okay.
Lordship, I beg to mention item number 22 and 23, Lordship. Lordship, the leading counsel is indisposed. He's out of station.
You are
It
for?
is, I'm for the respondent, Lordship.
The petitioner is present.
Yes.
So, objection?
Your
But then-
Worship, last time the court has directed the parties to
Hmm.
submit a gist of the written arguments.
Right, right.
So what are they written with that?
So when do you want?
Next Monday, coming Monday, Lordship.
Is it okay? Monday?
Monday, okay. But that time, let them submit the written gist of written submission also.
Okay. Have you submitted written submission?
Not yet, Lordship.
Okay, so on that day you come prepare with the written submission?
Yeah.
Okay. Mr. Sidrungson submits that the leading counsel for the respondent is out of station, therefore pray for listing this matter on Monday, to which
Monday would be
the learning
seven.
to which the learning counsel appearing on learning counsel for the appellant has no objection. Accordingly, the prayer is allowed. List this matter after on Monday, on Monday, on which date the respondent, number 7, no, respondents. Have you submitted your written submission?
I'm ready,
Okay,
not yet submitted.
okay. Shall also submit a written, also submit a written submission, okay. Come prepare with the written submission. Written argument,
Yes,
okay,
Yes, sir.
okay.
obliged.
Much obliged.
May it please your Lordship, I'd
Yes.
like to mention item number 32. On the consensus of both the parties, let this matter be listed after 3 weeks.
Item
32.
32 already mentioned.
Your Lordship, my apologies. Then, in that case, there is interim.
32, there is interim. Just see. In 32, and the interim order passed earlier shall continue till the next date. Okay. Okay.
Lordship, if I may be allowed to mention item number 9, Lordship. We are here to receive instructions, Lordship, so.
Yes, yes, you are also counter not yet filed. You are Mr. Okay. Your name is there? No. Mr.
Mr. Manum, H. Manum Koya.
H. Malam.
I'm appearing for on behalf of my senior.
He is present on behalf of Mr. Supamati Waling, Learned Counsel for the petitioner, staff. Ms. Cheng, Learned Government Advocate appearing on behalf of the state respondent, submits that she is yet to receive instruction in the matter and therefore pray for further 3 weeks' time to obtain instruction and to file affidavit in opposition. The prayer is allowed. List this matter after 3 weeks.
Lordship,
Okay.
Lordship, I have similar prayer for item 12, Lordship.
Yes, 12 also not yet filed. Whether the petitioner is present here in 12. Okay, your good name?
Rebecca.
Okay, so replace the Rebecca, same, okay, similar order. Here also 3 weeks,
Lordship,
okay.
Lordship, similar prayer for item 13 on behalf of IME. Lordship.
13 also not yet filed,
Lordship,
I've seen,
13, 1-3.
1-3. Whether the petitioner is present here in 13?
Lordship, I'll inform them. I'll inform them.
No, whether,
Same petition, Lordship.
same petitioner,
Lordship.
okay, who appeared just now in the above? Okay. Just inform, then we'll record the same, similar, huh,
Lordship.
with 12 and 13, same. You inform. Okay. You are Rebecca.
Yes, Your Lordship.
Okay, she is praying for adjournment,
No
seeking
objection.
some more time.
No
Okay,
objection.
okay, same,
Pleasure.
similar order.
Please, Lordship.
Yes.
Lordship, I'd like to mention item number 34. On behalf of the council for respondent number 1, PN Sharma. On a consensus prayer, Lordship, if the matter can come up after 2 weeks.
Why? This is a make appeal.
Yes, Lordship.
Why?
Lordship, the leading counsel, B.N. Sharma is indisposed. The matter can come up of 3 weeks.
Who is indisposed?
The leading counsel, B.N. Sharma.
B.N. Sharma.
Yes, counsel for respondent number 1.
Yes, Mr.
No also on behalf of B.N. Sharma.
Submits that the leading counsel for the respondent number 1,
Lordship.
Mr. B.N. Sharma is indisposed, therefore prays for adjournment, to which Mr.
Chuba, on behalf of Tayong Chuba.
Okay, Chuba, appearing on behalf of Tayong Chuba, learned counsel for the appellant, has no objection. Accordingly, the prayer is allowed. List this matter after
3 weeks, Lordship.
3 weeks.
Lordship.
Yes.
For motion, item number 1.
Please, Your Lordship.
Yes.
This IA is filed under Order 1, Rule 10, for striking off the name of the present respondent, that is DC Dimapur, and to add implement the new respondent, DC Chumukedima. Your Lordship, this contempt petition was initially filed against the DC Dimapur for willful and deliberate violation of the court's order. However, during the pendency of this contempt petition, a review petition was filed by the respondent seeking submitting that after the government notification dated 12/20/21, the petitioner's village comes within the jurisdiction of DC Chumukedima and not DC Dimapur. The review petition was allowed by this honorable court. Hence, the applicant is constrained to file this IA.
Miss,
Chris Akira.
learned counsel for the applicant, stop. In view of the order dated 30/9/2024, passed in review petition number 3/2024, the prayer for striking of the name of the present respondent, Dr. Tino Zongsi Chang, Deputy Commissioner, Dimapur, and to implement the Deputy Commissioner, Chumukadima, as new respondent in contempt petition number, in civil original petition contempt number 8/2024 is allowed. Stop. With the above, this IA stands disposed of. Okay, and in the main contempt. In view of the order passed today in IA number 34/2025, what is the name of
Sri Polam John, DC Chumukedima.
What is the name of the present DC of Chumukadima?
Sri Polam John.
Where have you written in the
It's in the
application?
prayer, page 4. Para 5.
Para 5?
Sri Polanjan, DC Dimapur, DC Chumukadima.
Pair of 5 of
Para 5 of the IA.
IA.
Yes.
IA 34.
Yes, Your Lordship.
Pair of 5 is bona fide inter. No. Okay, in the prayer.
Yes, yes, Your Lordship.
Let Sri Polan John, Deputy Commissioner, Chumukadima. It's not complete. Oh, Chumukadima. Where is the complete address of this present? Where is the complete address
Your Lordship, it's written
of the
para
person to be impleaded?
in para Deputy Commissioner Chumukadima.
Name of the. How do we adjust unless you give proper address, name, address of the person to be impleaded? How do we adjust from here and there? The address is of the earlier respondent. You have to
No,
give
Your
the proper name and the present address clearly.
Your Lordship, it's reflected in para 3, Sri Polanjan, Deputy Commissioner
Where?
Chumukadima. In para 3.
Dr. Tinojin Chang, Deputy Commissioner Dimapur is the respondent and for including the name of Sri Polanjan, Deputy Commissioner Chumukadima. Okay. Polanjan. Only Deputy Commissioner is respondent. Okay. The Deputy Commissioner Chumukadima is, he will be respondent number?
1, sole respondent.
You have not mentioned sole respondent?
Yes, Your Lordship.
Okay. Is the respondent. The petitioner shall amend the cause title of the contempt petition by reflecting the change in respondent from DC Dimapur to DC Chumukadima within a week from today. Staff, the registry shall also do the needful stuff. Notice to be issued to him.
Lordship, after amendment of.
And after amendment. So after amendment, this will be listed, then only we'll pass order then.
Your Lordship.
Okay.
Please.
List it after a week. After a week?
Yes, Lordship.
Okay.
Much obliged.
For admission, item number 2.
May I please, Your Lordship?
Yes.
I'm Mr. Lelamtong PM Chonga, appearing on behalf of my senior, his no him. Last time, we have seek time to seek instructions for the 6 petitioners, whether they have registered in PIMS as per the office memorandum issued by the Chief Secretary, Government of Nagaland. That's the petitioners have already registered. They have already registered in PIMS. Therefore, the humble petitioners would like to apprise your honorable court that the matter is clearly governed by the provisions of the office memorandum issued on
Just a minute.
5th March 2025.
So what is this? Oh, notification. Does it cover, Ms. Mary?
Lordship.
Okay. So
Better make
all
it
of them
difficult.
were working as a WC. All the petitioner. Okay. Have you mentioned here that when their initial appointment was?
This OM applies to all the board church employees.
Okay. So just 4. in the petition, we need to mention when he was first appointed here. Just a minute, when the petitioner number 1 was appointed first?
23/05/1991, Your Lordship. In page
Petition
number
number 1
6. Yes, 1991.
is WC unskilled. Okay, and then what about the petitioner number 2? What about the petitioner number 2? All of them were appointed on the same day.
Yes, Your Lordship.
Okay, where is the appointment order? Appointment order. Just let us see once. They were appointed by the same
Yes, Your Lordship.
appointment order. Let us see just. Okay, 6 of them
Yes,
on
Your
the
Lordship.
same day. Okay, they squarely cover, I think, then. On the same day, all of them were appointed. So all of them are posted in a different place or are in the same place? It was
Same place,
under
Your
the
Lordship.
same subdivision.
Yes.
Okay, you file writ petition earlier also. Okay. Okay, we'll dispose of. It will be similar order dictated. Okay. We'll dispose of. Okay. Give me the. It will be same order, similar order.
A time frame of 4 months, maybe.
Here in this case, 4 months.
Yes, Your Lordship.
Okay. Okay.
Okay, much obliged.
Give in chamber, huh? Okay.
For admission, item number 3.
May I please, Your Lordship?
Yes.
Lord, I am appearing through VC, Lord. Lord, on the last date of hearing, I am in receipt of a letter that is a notification dated 18th of March 2025. That is the appointment of Shri Tongpang L. Jamir, Advocate, Gauhati High Court, are hereby engaged as arbitrator. So, my Lord, this letter does not clear that whether he has been engaged as an arbitrator or as a counsel to defend this case, because in the last line it is mentioned in the Gauhati High Court Kohima bench to represent and defend the government of Nagaland. So, my Lord, the arbitrator cannot.
What is this notification? What is this notification about?
This notification is about the appointment of arbitrator. My petition is for the appointment of arbitrator. Now, after several dates taking for the instructions.
Just a minute. In person to the government of Nagaland. Okay. So this is appointment of arbitrators.
My petition is for appointment of arbitrator. Now, this letter says that Mr. Tongpang Jamir Advocate are hereby engaged as arbitrator in case number, the present case, arbitration petition 4 of 2024. In the Gauhati High Court Kohima bench to represent and defend the government of Nagaland. So, my Lord, this, as per my wisdom, this letter is not happily worded because an arbitrator cannot defend or represent any of the parties.
Yes, sir. This is not the person who has been have been appointed as arbitrator for the case.
Not, they are saying that
To
he has been
arbitrate,
engaged.
to arbitrate the case.
No, he is not the, he cannot be
Yes,
appointed.
that
as-
is why.
So they have to file the reply to my petition.
Yes. Have they filed?
No, they have not filed.
Yes.
Lordship, if my lord may turn to page 147, page annexure 19. Annexure 19 of the petition, of the petition.
Just a minute. Where is the other records of this case? Oh, it's here.
Lordship, relevant part is
Yes, yes.
paragraph 2, Lordship. Page 147. 147.
Just a minute, wait. No problem. 147.
Yes, Lordship. Annexure 19, Lordship.
Yes, what is this?
Yes, here a letter was written to the director lottery. Request for request subject is request under section 11(2) and 3 of the Arbitration and Conciliation Act 1963 as amended for appointments of arbitrators. Now the relevant part is paragraph 2, Lordship. Paragraph 2 on the same page.
Just a minute. Office. Yes, paragraph 2.
Yes. That further, since no procedure has been prescribed in the agreement for the appointment of arbitrators, therefore my client proposed, this is what they proposed, Lordship. The arbitral tribunal to adjudicate and decide the claims of my client against you, dispute raised by you against the claim, B consists of 3 arbitrators as provided in sub losenso of the Act 1996 as amended, so that each party shall appoint 1 arbitrator, and those 2 appointed arbitrator shall appoint the 3rd arbitrator, who shall act as the presiding arbitrator. My client therefore proposed the following name as his nominee arbitrators as under, and according they have appointed nominated 1 arbitrator, Lordship. So in response to this, the department has also nominated 1 arbitrator from the department side, Lordship. Well, however, if this is not agreeable with the petitioner, then
now each party has to appoint 1.
Yes, that's their
and
proposal.
these two
yes
person being appointed by each of the party will appoint another.
Yes.
1 more.
The presiding arbitrator. Yes.
Okay.
That's their
So this was written by
from the department side, Lordship.
This is advocate.
Yes. This notification is from
Now you see,
yes.
the prayer is for appointment. Are you objecting, or are you just you want? You can file affidavit saying this. That
But
this
may I
was
submit one?
agreement. If there was an agreement to appoint each arbitrator by the party, and then the arbitrator being appointed by the party shall appoint another.
Yes, Lordship, that was a proposal given to the department by the petitioners, Lordship.
Oh, this is given. You have objection.
No, not Mujib. So accordingly, that from the department side, they have come up with a notification appointing one, nominating one arbitrator.
Okay.
So now they have, as per this annexure.
Okay. So have you seen this letter?
I have seen this letter, my lord.
Okay. After this letter, they have appointed the notification which you have just placed.
My lord,
This is arbitrator from their side to defend their case.
my
And
humble submission
now
would be,
it's you to appoint one arbitrator.
my lord, my humble submission would be, after this notice annexure 19, which my lord have just read, the parties have ceased to appoint the arbitrator after the filing of the petition under section 11. This is as per the honorable Supreme Court in 2006. I have just applied the copy in the morning also. My lord may kindly see
Okay.
that
So
judgment.
that means this.
So what I am suggesting is my lord may appoint any retired high court, honorable high court judge as a sole arbitrator.
No, according to you, this letter dated 12/8.
Yes. This is my letter
It's
requesting
no
them to
longer
appoint the
applicable
arbitrator.
now. This is no longer applicable now.
No, no longer applicable now.
Why?
Once I have moved before this honorable court, the parties have no right
You
to
heard
appoint
him.
the
You heard him.
arbitrator.
Once you move, because the provision, as per the provision, once any party moves before the High Court for appointment of the arbitrator, then this will not remain no longer applicable.
That is understood. But if they are trying to resolve something, I think they should understand. But if they want to go technical, very technical, but
No, that is why now they are going technical.
Yes.
So as per the
They are
provision.
claiming bills, Lordship. So we are trying to resolve that. But if technically they want to resolve, go for appointment of the.
No, whatever maybe, probably now now because he is objecting now this.
Okay.
You need to file affidavit. It
Lordship,
appears.
in that case, give us some time, Lordship. Yes.
File.
Yes.
Because earlier this proposal and then after filing of the filing
Yes.
of this writ petition for appointment of arbitrator that no longer exists.
We thought this is in the interest of the the petition, but if there is
You can make proposal also. Okay. Okay.
My lord, if I may submit only one thing also again.
Lordship,
you are Mr.
Amit Parashar.
Amit
Parashar.
Parashar, Lani counsel for the petitioner, staff. Mr. Angami. Lani counsel for the respondent. Praise for how much time?
3 weeks, Lordship.
3 weeks time. 3 weeks time to file affidavit.
To obtain necessary instruction.
To obtain necessary instruction and to file affidavit in opposition if required. Okay. The prayer is allowed. List is matter after 3 weeks.
Bless you, Lordship.
Okay.
Grateful.
For admission, item number 4.
Please, my lords, I beg to appear, my lords, for the petitioners. This is a quashing petition for quashing of an FIR under section 420 of the IPC, my lords.
Yes.
Yes, my lords. My lords, this is for admission hearing, my lords. This is a quashing petition for quashing of an FIR under section 420. My lords will find the complaint at page 48.
No, in the last occasion.
Yes, my lords.
Also, petitioner submits that the case pertaining to this matter involved in this case is listed before the apex court. What is this?
So, my lords, your lordship had passed an order on 30th January, my lords, whereby your lordship was pleased to decline to extend the interim order. Against that order, my lords, we preferred an SLP before the Supreme Court. The Honorable Supreme Court has passed an order granting us some interim protection. My lords, my colleague will hand over that order. But, my lords, there is no prohibition today to go ahead with the quashing petition, my lords, because that's on a separate point. We had filed an SLP against an interim order, my lords.
Yes. Okay, during pendency.
Yes, my lord. So Supreme Court, my lords, has protected me during the pendency that I will not be arrested. My lords, that was on a limited point that we had gone to the Supreme Court.
Yes.
Yes, my lords will see the complaint at page 48.
So they have obtained interim till the, of course,
Milords, the state was
till
represented in
returnable
the
date only.
Yes. Milords will see page 48, which is the
Just a
complaint,
minute,
Milords.
just a minute. Page 48.
48, Milords.
Oh, what is the page 48?
Milords, 48 of the petition.
What is that?
That's the complaint, Milords, basis which the FIR was registered.
Yes.
If your lordship permit, with your permission, if I may read, with utmost respect, I so-and-so of so-and-so engaged into business as distributor with AK Jain Sales and Marketing Private Limited from 2013 till date. Milords, may kindly note this is 2019 and I will show you from the complainant's documents. The transactions in question are from 2013 to 2019. Milords, may kindly note that. Milords, I'll come to that shortly.
Your type copies doesn't show anything.
Milords, because in the complaint
Type
also...
copy at page 11.
Yes,
of-
Milords. Milords, because in the complaint also they have not written anything. Milords, I am requesting your lordship may make a note that this is 2019. This is clear from the legal notice. May I read, Milords?
Could have corrected here in the type copy. You
No,
have
Milord.
actually submitted type copy.
Yes, Milords, because the complaint is exactly like this. There are other documents which will show that the transactions are from 13 to 19.
Just a minute. This is type copy.
Yes,
And
Milords.
page number you said?
48, Milords.
48.
Yes, Milords. Milords, it's exactly the same.
No, 40.
48, Milords.
48.
Yes, Milords.
What is this? Just a minute, sir. 48 of the petition.
Yes, Milords. Milords, there may be an interim application also. Milords, I am referring to the page numbers in the petition.
Yes. Page 48.
Yes, Milords.
Okay. From 2013 till date. Is
Dot. Yes, Milords. But Milords, I will show some other documents if I may read, Milords. On implied, confirm and valid order, where on the condition that the expired damaged goods will be recovered. During the course of performing my duties, I had received damaged expired goods, which was deemed acknowledged by the company through its representative. However, even after continuous claim for damaged expired items for the outstanding undisputed amount of 40,58,813, the company representatives, on the pretext of several reasons, did not pay heed to replace the today. It is fact that they had acknowledged the damage notices to this effect. They had paid lip services to compensate. However, no such payments are made. The company and its agents are playing nefarious mischief under nefarious schemes with the intent to cause loss to my business and reputation in the estimation of my customers vis-a-vis the public. The company and agents, even after knowing fully passing the buck to each other to circumvent the responsibility of delivering the products which are damaged nor compensated the damage, the deliberate action of the company and its agents has imminently endangered my existence to engage in any business undertaking and outrightly damage my reputation and estimation. And my lords, the last paragraph is for the complaint. My lords will now see the next page. Milords, they have given the names of the various accused persons. The first is me, AK Jain, Sales and Marketing. Milords, from 2, 3, 4, 5, 6, 7, Milords, this is the manufacturer, which is Pran Group. Milords, I am only a distributor. I bring goods from the manufacturer Pran Goods. As a distributor, I then supply to the retailers like the complainant. Milords, that's the arrangement.
No, just a minute, sir. Whether the respondent appeared.
Milords, the respondent notice has been served, Milords, but they did not appear.
The respondent need to appear.
Milords will see the order dated 30th January. Your Lordship has noted that. Milords, may kindly see that order of 30th January. Page number 5 of that order. Milords, para 3, since no one appeared.
30th January 25.
25, Milords. Please, Milords. Para 3.
Wait a minute. Yes, where?
Milords, page number 5, para 3, since no one appears on behalf of the respondent number 2.
Page number 5? 5
para
of?
5 of that order, Milords.
30th January 2025.
Please, Milords.
It's only up to page 3.
Milords, I'm sorry, Milords, the web copy has that. Milords will see the last page, third last paragraph. Since no one appears, the last page records of that order records, Milords. Since no one appears on behalf of the respondent number 2, despite receipt of notices, it is presumed that the notice upon the respondent number 2 is complete. The learned public prosecutor submits that she is not going to file any reply, any affidavit in opposition. However, she prays that she may be allowed to produce the updated case diary upon which she would be relying for her arguments on the next date of hearing.
Do you have the updated case diary today? Okay.
So, Milords, the service is complete. Milords, the respondent has chosen not to appear.
City update till dated 23/9.
It is available on the court.
Yes. I've already handed over.
The detail
Yes.
or the, okay.
In fact, the investigation could not proceed because of this FIR petition, Your Lordship. Investigation could not be proceeded. It was hold at the threshold, Your Lordship.
No, thereafter it was vacated.
It was
It was not
vacated.
extended.
It was not extended, so the IO has applied for the NBWA again. So the process is under, Your Lordship. The investigation is under process, Your Lordship. But then.
Now,
the
unless those statements are produced, then no
Your
point.
Lordship, the accused is not cooperating with the investigation.
No, that is why I'm saying.
Yes.
Now, how do we dispose of the matter unless?
Your Lordship, whether the question, whether the question of FIR will arise at this stage, Your Lordship, that the Supreme Court is very clear in some that case, Your Lordship. If I may be allowed to place the case.
Milords, let me complete the learned public.
Just a minute.
Yes.
See, at the threshold,
Yes.
the initial stage,
Yes.
the court made an observation that there will be no coercive action against
Yes, yes. Your Lordship,
the petitioner. And thereafter, it appears that the petitioner did not appear before the eye of the case. And now the PP says that you are not cooperating with the eye of the case. Then one way the investigation of the case was kept on hold, under hold. It did not progress after that order, probably. But then, of course, investigation could have continued. But then probably IO have misunderstood the order. So he did not progress the investigation itself, it appears. Then unless the investigation of the case taken place and some findings are made, how do we come into the conclusion
Exactly,
for hearing?
Milords, with greatest respect,
Unless you cooperate.
No, Milords, with greatest respect, Milords, this is not a bail proceedings.
Just
Where-
a minute, huh? What is this letter, by the way? This is not a letter. Updated case diary. What is this, dear sir? Whom it has written? Who has written this letter? Miss Mary? What is this?
Milords, there are multiple letters.
Record of a statement in virtue. Okay.
This
Request
is
for
just a part
virtual-
of, yes. Part
Milords,
of the.
may I?
Statement was
Milords, may I?
That's what
May
made
I
the
say
whether he was
applicant-
examined virtually.
Yes. But then the IO is not satisfied. That's why that was not allowed, Your Lordship.
Milords, may I say this, Milords?
Just a minute, huh? This letter speaks something.
Milords, that's my letter to the IO. Milords, I have said that I am ready to
Okay,
cooperate.
You see, other than this, your letter, there is nothing in the case
No,
diary.
Milords, with greatest
Investigation
respect,
itself
Milords.
not progressed.
No,
Yeah.
Milords,
It
with
is-
greatest
Now, why don't
respect.
you progress? Because even if there is a court orders not to take coercive action,
It
or
is
even
not a
there
force
is
action. No, Your
but
Lordship,
then you
that's-
say you are at liberty. Nobody prevent you from
Investigating.
taking out the investigation.
That is preventive in nature, Your Lordship. That order itself is preventive in nature.
No, that was subsequently vacated.
Subsequently vacated, and that's why after the vacation, the IO has taken steps, Your Lordship.
Now he's taking.
Yes, Your Lordship. So
Now
it is
you
satis-
cooperate.
Yes.
Well, you cooperate.
I have-
The quashing petition cannot,
Yes.
unless the investigation progress, unless in the investigation, if the IO finds out or not find out, unless IO gives some material at least to examine by this court.
No, Milords, with
There is
greatest
nothing to examine, nothing to
Milords,
examine.
with
Yes,
greatest
because you have
respect.
never appeared.
Yes.
No, Milords, with greatest respect, Milords,
Hmm.
that may not be relevant. In a quashing petition, your lordship knows
No.
that, Milords, I am challenging the very
Based
registration of the FIR.
based on FIR only, can
Yes,
the
Milords.
court
Yes,
progress?
Milords. The registration of the FIR itself is, Milords, valified. So your lordship, Milords, will not be bothered itself with what happens in the investigation. That's the second step. Today, Milords, I have come before your lordship on the argument that the registration of FIR itself is bad and that could have never been registered.
No,
So,
no.
Milords, what happens with the investigation, your lordship, Milords, that cannot be a reason, Milords, to not hear the quashing petition today.
The complaint itself discloses a case for investigation. Your
Yes,
Lordship.
Milords, in that situation, let me place my submissions.
So it has
The
come to
learned PP will have a chance to
logical
argue.
conclusion.
Milords, in that case, your lordship may just hear my submissions and decide the petition, Milords.
And then why IO did not record a statement of the informant?
Your Lordship, the informant, it has been recorded, Your Lordship.
Okay, where
The
it
first
is?
page of this. First page of this CD dated 22/5/2024.
CD.
Yes, Your Lordship.
Earlier CD was with the court.
Earlier CD, yes, I've handed it over. And
It was not returned.
it was not returned.
Okay, just a minute.
The statement of the complainant is at page 3 of the CD.
Yes.
Yes, my lords.
Yes.
Your lordship,
Your lordship, the Supreme Court is very clear. When the investigation is at its threshold, it cannot be quashed, your lordship. Lordship may kindly refer to some Chief Malik case, your lordship. It's an SLP filed against the judgment and order of Supreme Court quashing criminal proceeding, and the same was allowed, your lordship. The appeal was allowed, your lordship. Para 16, 17, and 18, your lordship.
Yes.
Yes, Milords, I am not aware, Milords, what my friend has cited. But Milords, my case is very simple today. Milords, I have come before your lordship on the ground that one, if your lordship were to take the allegations made in the FIR to be true, in that case also, Milords, no cognizable case is prima facie disclosed, and therefore the FIR must be quashed. Number two, Milords.
But as we know that FIR is not an encyclopedia of all allegations.
Please, Milords, I beg down, Milords, I bow down to what has fallen. Milords, there are 2 or 3 grounds on which, Milords, I have come before your lordship. Number 2, Milords, this FIR, Milords, has been filed with an ulterior malified motive only to wreak vengeance. And Milords, I will show from the complainant's own documents.
You appear and then you clarify before the eye of the case that
Milords, Milords, that's a separate
Why don't
matter.
you appear?
No, Milords, I have no difficulty.
What is your problem? What is your problem?
Milords, I have no difficulty in appearing
before the eye of the case and just clarify.
Your lordship.
For clarification, you can also file counter FIR. But why you are worrying?
No, Milords may kindly bear with me for a minute. Milords, I have no difficulty in cooperating with the IO. In fact, I have written him multiple letters The IO has not responded. And my lords, I assume those will be
IO
in the
doesn't
case diary.
require any letter. See, you need to appear as you are accused.
No, my lords,
Accused need to appear. Accused need to appear as in when IO when called for.
my lords, I bow down.
Agreement.
My lords, I bow down to that. My lords, it's only due to medical reasons that I had requested the IO to take my statement virtually. The IO has not even responded to that.
Medical ground for since when?
My lords, since about a month,
Cannot
my
be
lords,
full time.
I had also filed an additional affidavit. But my lords, the point today is, my lords, there is nothing which prohibits your lordship to hear my quashing petition and decide it on its own merits without the investigation.
See, there it appears there is nothing now as of now.
Yes,
because
my lords, that's the whole
FIR.
point.
There is only FIR, and on the basis of FIR, it will be very difficult for me, especially for me. It will
No,
be very difficult to come into conclusion whether there is material or not material, unless
May I
some
show a few things?
comes from the eye of the
My lords,
case.
may I show a few things, my lords? My lords will just bear with me for 2 minutes.
Yes, please.
My lords will see, my lords, before the complainant filed the FIR, there was a legal notice which was sent to me. Your lordship will see the legal notice at page 67. My lords, may kindly see that for a minute. Page 67 of the petition.
Page 67.
67, and this is my lord's complainant's own document. This is not my document.
Yes.
Your lordship will mark the date 23rd December 2023. Your lordships have that?
Yes.
Your lordship will now see the next page, paragraph 3.
Yes.
My lords, the dates are extremely relevant. This starts from 2013. The last transaction is March 2019. And my lords, the case of the complainant in his own legal notice is that I was given expired goods from this period. And my lords will see the total loss he is claiming 38 lakhs. This is, my lords, my case today before your lordship is, this is a completely pure civil dispute. Instead of going to a civil court after 5 years, my lords, the last transaction is 2019. Your lordship has seen the complaint, which was filed in 2024. No explanation, no justification. The only reason, my lords, the complainant has filed this is because he doesn't want to go to a civil court, although this is a purely civil dispute. And my lords, there is a second legal notice also. I responded to that saying that there is nothing outstanding. Then, my lords, he sent me a second legal notice, which is at page 71. So, my lords, on the face of it, my lords, your lordship will see this FIR is malified, my lords. That's my exact case before your lordship today. Page 71, my lords, will see the second legal notice. My lords, the date in the second legal notice is at page 73, my lords, in the end. This is 8th January 2024. My lords, at the bottom, your lordship will find on the left-hand side the date. In this one also, my lords, he is claiming 38 odd lakhs. Then, my lords, after 2 months, he files a criminal complaint, doesn't mention about this, and the amount, my lords, interestingly now changes to 40 lakhs.
Yes, Miss Mere.
And, my lords,
There is
may I just, my lords, one thing, my lords. I just want to show one judgment, my lords. My colleague will hand over, my lords, one Supreme Court judgment. On the face of it, my lords, there is no criminality. This is a purely civil dispute of 2019, my lords. The last transaction happened then.
No,
Today,
the allegation is, you said that once good is reached to the party address and our responsibilities ends thereafter.
Yes.
The circumstances, what the petitioner can do.
No, my lords,
The respondent.
my first point is, my
So-
lords, if these transactions
Without
happen from
responding, without responding, if you say it like that, then it will be trouble.
No, my lords, may kindly see the judgment, my lords. One judgment I want to place on record, my lords.
What it says.
Yes, my lords, this is Mahmood Ali versus State of UP.
Yes.
This is 2023 Supreme Court Online 950, my lords, will directly come to para 11. First, my lords, I want to show your lordship the settled principles on which your lordships have the power to quash an FIR. My lords, the Bhajan Lal principle, as your lordship may know, my lords. Para 11. Yes, my lords. Para 11, my lords, first.
Para 11 of Mahmood Ali.
Yes, my lords.
Yes.
Yes, if I may read, my lords.
Yes.
The entire case put up by the first informant on the face of it appears to be concocted and fabricated. This is my case. At this stage, we may refer to the parameters laid down by this court for quashing of an FIR in the case of State of Haryana versus Bhajan Lal 1992. The parameters are, my lords, if I may read, where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Number two, where the allegations in the first information report and other material, if any, my lords, I am not relying on this, I am relying on one, and my lords will straight come to next page, number 7. These are the two parameters, my lords, I am relying on. Where a criminal proceeding is manifestly attended with malafide and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. And my lords will then see para 13. Your lordship has para 13?
Yes.
Yes, my lords, this is extremely important what the Supreme Court says. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under Section 482 of the CRPC or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or the criminal proceedings quashed essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR and complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous and vexatious proceedings...
You think this is in your favor?
Milords, may I just read, Milords?
Yes.
This part, Milords. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, to read in between the lines. Milords, I am relying on this, Milords, because your lordship will see the legal notice that came few months before the FIR was lodged. That legal notice, Milords, very clearly says that the alleged transactions took place from 2013 to 2019. After 5 years, Milords, from the last transaction, they make a complaint against me. In the complaint, Milords, one of the essential ingredients of cheating.
See, the allegation is you kept on assuring that you will pay. It appears that that is why they did not file complaint earlier.
No, Milords, but from 2019 to 2024, Milords, about 5 years. And Milords, in the legal notice, they don't say that. Milords may kindly see the legal notice that they sent few months ago. That was the first time they sent me a letter. So, Milords, my case today, Milords, is entirely that if your lordship
Anyway,
were to-
anyway, see, you want this court to dispose of this matter today on the basis of your submission, on the
Yes.
basis of the FIR only?
Please,
Or
my lord.
you want to clarify by appearing before the eye of the case? It's your choice. I'm
No.
giving an opportunity.
Milords, with greatest respect, Milords,
Hmm.
it is immaterial, Milords, what happens in the investigation. Today, I have come before your lordship only on the ground that the institution of the FIR itself is wrong. So therefore, Milords, may kindly, Milords, dispose the case basis my submission. And may I just place one more judgment, Milords?
So this I am recording that without appearance before the IO of the case, that you want this IO, matter to be disposed of on the basis of the FIR.
Milords, may kindly also record that I have
Want me
sent
to
letters.
record that?
No, Milords, I am not saying that, Milords. All I am saying before your lordship today is,
I think
Milords,
you take chance. The case, you are being protected by the Supreme Court, and then even
No,
if
Milords, may I
arrest
just-
also, it's always better.
Milords, may I
It's
just
better.
request this? Milords, may I request
better,
this? Milords, may I request this? Milords, I bow down your lordship as
Because that even if this case is goes against you, then again you say you'll be filing again appeal before the Supreme Court. That will amount the advocate troubling with the client itself, because
Milords, may I-
you want to protect the client, your client, but then that will not help
Milords, may I just say this?
in the
Milords,
process.
your lordship has been extremely gracious and patient with me.
Yes.
Milords, I have no difficulty in appearing before the IO. Milords,
Hmm.
my only problem
Appear
is today.
first. Let us see what you state before the eye
Yes,
of the case.
no, Milords, may kindly hear me.
Clarify, because there is an allegation.
Milords, may kindly,
You have been, you see, kept on postponing with the assurance that you will pay, but then never pay since 2013, it appears. And that is why ultimately it appears that the informant has filed complaint.
No, Milords, that's
Clarify. Let us see how you clarify.
Milords, in that case, Milords, may just kindly hear
Let
me,
us
Milords.
give
One
an
submission.
opportunity. Hmm.
Milords, one submission. Milords,
Yes.
I have made a request with the IO. Milords, I am based in Siliguri, West Bengal. My company's registered office is in Bikaner, Rajasthan. Milords, the complainant, of course, is based in Kohima. I have made a request to the IO that my statement be recorded virtually.
And the entire transaction and the business goes in that way only. But then when the matter comes, when the dispute comes, it's duty on your part also to clarify.
No, Milords, I will clarify. Milords,
We're not
will
saying
Milords,
that the transaction cannot be online.
no, Milords may just consider one submission. Milords, only one submission. Milords, all I am submitting before your lordship may give me permission to appear to the IO virtually. Milords, I will appear tomorrow itself. Milords, may just give me one chance to appear virtually, Milords.
Contrary to the order of the Supreme Court. This is clear.
Hmm?
This order is very clear, Your Lordship.
Which order?
The SLP order, the
SFD also you have undertaken to appear before
Yes.
cooperate
Yes, Milords.
before the eye of the case. You appears. And
Milords,
how the arrest can be made virtually?
yeah.
No, Milords, arrest
And immediately release. Even
No,
if
Milords.
arrest also, but hopefully there will be no arrest. But even if there is an arrest also, you have a protection.
No, Milords, my concern is different, Milords, and I will be very candid and frank with you. Milords, we are not evading from the IO. We want to cooperate. My only difficulty is, Milords,
See, while obtaining the interim order, you pray for before the court, before this court also, before the Supreme Court also, that you are ready to cooperate with the eye of the case.
Yes,
for
Milords.
of the case. And then now you see you are submitting different way again. Virtually, how it can be made?
Milords, my only
Because I'm
difficulty
giving
is,
an
Milords,
opportunity, huh?
there are some medical issues. I have placed those medical documents.
Okay. After medical issue, you take some time.
Yes,
Okay.
Milords, may give me some time
Hi,
in that
Mr.
case.
Mr. You are Mr.
Ayush Mitruka.
Land Counsel for the petitioner. Also had Miss Mary, Land Public Prosecutor for the state of Nagaland. So is prayed for by the Land Counsel for the petitioner. List this matter after 4 weeks. Okay. I'm
Milords,
giving you opportunity in between because you are under protection.
No,
And
Milords, may kindly record my submission that the petitioners are unwell and therefore they have not been able to
I
appear.
think there is earlier order also. Earlier you were given an opportunity to appear.
No,
That
Milords,
did not
Milords,
work properly.
Milords, in that case, Milords may kindly dispose of my petition, Milords. Let me take my chances, Milords, because Milords, this will remain pending. the police will continue to harass me, my lords.
No,
I'm
no,
sorry
no.
to say
There-
that.
There are some other witnesses also. In the meantime, the IO will record the statement of other witnesses.
No, my lords may kindly
Necessarily you, not necessarily you, because IO was probably under the impression that the protection order given to you was preventing him from proceeding with the investigation of the
Lords,
case.
I bow
Now
down in that.
you also instruct the IO to proceed with the investigation. There is
No,
no,
my lords,
there is no protection.
my lords may just clarify. My lords may just clarify in the order. My lords may clarify in the order, my lords. My lords may kindly clarify in the order.
Next.
7.
My lords may record my submission, my lords. I am aggrieved, my lords. By the way, my lords.
Yes.
Maybe it's a lordship.
My lords,
Yes.
may I make a submission, my lords? Your lordship will at least hear me.
Please, yes.
Your lordship will at least record my submissions, my lords.
Please don't disturb. Please not to disturb. On the prayer, it's to be listed after 4 weeks. After 4 weeks, if nothing happened, if you repeat, then we'll dispose of. Okay. Let us give an opportunity to the IO of the case to go ahead with the investigation of the case with regards to the other witnesses. If
Milords,
you're
that-
not ready to appear.
Milords, that is immaterial. Milords may not record my submission, Milords. I am not consenting to that. Your lordship may pass an order without my submission in that case. Milords, I will take my chances.
No. We are adjourning on the prayer.
No, Milords, I have not made any prayer. Milords may kindly record, then it's the prayer of the State Council, not my prayer, Milords. I am not praying, Milords, before your lordship to adjourn the matter. Milords, I bow down, Milords. This has been pending since September. Milords, nothing has happened. I have come before your lordship for quashing of the FIR on the material which is already on record. So, Milords, today, if the investigation happened, doesn't happen, that is immaterial. That is my submission, Milords.
Now you will be playing because there is a protection by the Supreme Court. You want this matter to be disposed of now.
Yes,
I'm
Milords,
not
may
going to
hear.
agree with that. I'm not going to agree with that at the moment.
No,
Let us give
Milords.
an opportunity to the IO of the case.
No, Milords, in that case, your
I'm
lordship
giving an opportunity to the IO of the case to proceed with the investigation of the case so that at least some material comes before this court to dispose of on the
No,
basis,
Milords, your lordship may do that, but your
on the
lordship,
basis of the material on record. Okay.
Milords, your lordship may do that, but not on my submissions, Milords. I have not made that submission.
I'm saying
Your
no,
lordship,
I did not say that on your submission.
Milords, your lordship has recorded at the submission of the councils, Milords. May kindly not record that, Milords, so that I can, Milords, take my remedies in accordance with law.
Is prayed for by the Lana PP. Okay, make it. On the prayer of the Lana PP. Okay.
Milords, but your lordship will record my submission that I am ready for arguments. My submission be also recorded, Milords.
At the moment.
Yes, Milords.
I'm not ready to hear at the moment when
Yes,
the
Milords,
pray for adjournment of the matter.
Milords may reject my submission. At least your lordship may record my submission that I am ready to argue the petition.
Okay,
But your
then-
lordship has decided to adjourn the matter.
Okay. On the other hand, the Lana Council for the petitioner is ready for argument based on the FIR. Okay. Or on the prayer, okay, be that as it may, on the prayer of the Lana PP, let this matter be decided after 4 weeks. Okay.
Grateful, Milords.
Yes.
That is, my lord. Lordship, I pray that this matter be listed on Thursday, lordship. The leading council isn't disposed, lordship.
Leading council for
For the state response, lordship.
state.
Lordship.
I think
It isn't
it's-
disposed, lordship.
if it is if it is regarding the scale of pay, it's all the same. Let us see the prayer once. Okay, if it is all the same, you can also take up.
So lordship, I don't have to brief with me, lordship.
The scale of pay only. There is a notification you have heard
Lordship.
earlier. If it is a scale of pay, it covers only, squarely covers only. Because the government gives a notification in the earlier, what was the item? The prayer is only for giving scale of pay only. See the petition.
Lordship, let this matter be listed on Thursday, lordship.
Thursday, okay,
Lordship.
let's pray for by Miss Chang, Lara Government Advocate, appearing on behalf of
IME, lordship.
IME, Lara Council for the respondent. List this matter on Thursday again. Okay.
Much obliged.
Right, lordship.
For admission, item number 8.
Lordship, here is a similar prayer, Lordship. Then,
8 also scale.
yes, Lordship.
Yes, your lord.
Here also IME.
Lordship.
Yes.
Okay, okay, similar
Yes,
order.
sir. Obliged, Lordship.
For admission, item number 16.
Yes, what is this? Yes,
May it please your lordship.
yes.
Lordship, here the petitioner is the husband and the wife of the petitioner.
Whether case there is ready? Is there any material? Huh? Have you seen the case diary? Any incriminating material found against the accused?
Judge, and can you refer the inquiry, submission of the inquiry report here? Lordship? The loose sheet.
Just a minute, huh? Let
Yes.
us see the FIR first. This is inquiry report.
Yes, sir.
Okay, just let us see the FIR. Wait, huh? Okay, page 26, just a minute, huh? Okay, so this is allegation.
Yes.
Inquiry, let us see the inquiry.
Your Lordship, this case is like, the anticipated bill, the first anticipated bill was taken up on 11/2/2025, Your Lordship. And it was, ad interim was granted, Your Lordship. Interim was granted and it was fixed on 26/2. The matter was supposed to come up on 26/2. However, on that day, on 26/2, the matter could not be taken up because I'm learned PP. I have enclosed the order also, Your Lordship, as to why the matter could not be taken up on that day. So, Your Lordship, since that PP was engaged in other court, the court adjourned the matter, making it like at the interim, and accordingly, the interim was extended till the next day. So, according on 28/2/2025, again, the secretary bill, a petition was taken up, Your Lordship, for regularization. However, on receiving the inquiry report, Your Lordship, it was stated that from the IO that there was a harassment call. And therefore, Your Lordship, since the accused was not, the petition was not cooperating with the investigating officer, and therefore the district and session judge rejected, Your Lordship, the anticipatory. And accordingly.
Whether during the pendency of or during the interim period, whether
during
the
the interim
accused
period.
appeared before the eye of the case?
Yes, Your Lordship, they, on 22/2, Your Lordship, interim.
He appeared.
They appeared, Your Lordship. Before appearing, they made a harassment call, Your Lordship. If you can come to the third page.
Whether during the interim protection period,
Yes, Your Lordship.
whether the accused appeared before the eye of the case to give his statement?
Yes, Your
Yes,
Lordship.
Your Lordship.
On
What happened?
several
And then
occasions, Your Lordship.
whether he was arrested, shown arrested,
Yes, he was formally arrested and then released on
released.
on furnishing surety as well as bail bond.
Okay. Then whether the said bail was cancelled?
No
No,
cancellation.
it seems that like there is no bail, Your Lordship. In fact, that is the, that.
No bail.
No, Your Lordship. Only the interim was granted.
Interim was granted, but he
Extended
did,
and-
no
yes.
arrest was made.
No. That is-
Okay.
Yeah, that is what I am instructed, Your Lordship.
Okay.
Interim was extended.
If he was already arrested, then that has to be
No.
cancelled first.
No.
Then thereafter only.
That
But
has
if,
not been met, Your Lordship.
Your Lordship,
Far
if
as
he did not,
instructed.
if he did not appear before the IO of the case, or he was not arrested, then of course, the interim protection can be cancelled.
Your Lordship, here on 20, if you can kindly come to the record, Your Lordship.
Record.
Yes,
So,
on 11/2, Your Lordship, interim was granted. And
Okay.
it was fixed on 26/2. Your Lordship, interim was extended till 26/2, Your Lordship.
Okay.
I have
Then
given
till
the-
26, he did not appear before the IO of the case.
No, so between this 26/2 and 11/2, he has made appearance, Your Lordship.
Appearance before the IO.
Yes, Your Lordship.
Whether the IO arrested him or not.
No, there is no
No
such
arrest.
thing. I
Okay,
inquired
then
and there was no
what?
such.
You said that he was arrested?
Yes.
Do you have the record?
Yes, there is a record. I've already annexed in my petition, Your Lordship, in page number 2, annexure 5A.
Page?
Page number 28, annexure 5A. So there is an arrest in court surrender form where all the formalities have been conducted.
Have you seen 28? What is this? 28 is particulars of the arrested person. It says particulars of the arrested person.
Yes, Your Lordship. Once a person is arrested, all these formalities are conducted, Your Lordship. As well as in page number
Just a
34, Your
minute,
Lordship.
just a minute. So I can address. He was taken into custody on 22 at 2 p.m.
And after signing a bail bond, which is annexed in page number 34, he was released, Your Lordship.
She misleading, huh?
Page
Have you
34.
seen this page 28? This I think is physical features also. Okay, the page
34.
What is 34? Bail bond. $20,000.
Yes, Your Lordship. And here his father, who is Tulsi Prasad, he has also appended his signature in the bail bond. And in fact, Your Lordship, on 22nd, he made appearance before the IO. Before that also he made an appearance. But on that particular day, he was made to...
So I think there is...
Yes, Your Lordship, the main issue is that, Your Lordship, what the IO has intimated in as what...
No, what is your instruction?
No,
IO says he was not
this
arrested.
instruction, Your Lordship, when I inquired, now it's apparent in the record, Your Lordship, so since it's apparent in the record, so it should be admitted, Your Lordship. However, no instruction from the IO. As far as the
You
welfare
just
was
obtain
concerned.
instruction, will take up tomorrow or day after tomorrow.
Yeah,
Your Lordship,
you
this,
obtain instruction.
this matter
because
has been pending for many times, has been adjourned several
Which
occasions,
one?
Your Lordship. Your Lordship, this matter has already come up in earlier occasions also. But since the IO did not send the report, it was adjourned, and this is the third time, Your Lordship.
No. Maybe. But you see, she has no instructions. She was furnished with only this inquiry report
Yes, sir, only the
and
inquiry.
CD and without
Lordship,
giving
the
any information
inquiry report
about
is the
whether he
instruction,
was
Your Lordship.
arrested or not, because that is important here in this case. If he was arrested and released on bail,
The document
unless
is clear.
we do not know. The original should be with her, with the IO of the case.
Yes, should be.
Let us confirm from the IO why IO should, what interest the IO have if he is telling lie and if he is furnishing insufficient information to you.
Yes,
Just
sir.
ask him also
I can
why he should keep this thing kept in keep the council from providing it to the at least the PP.
Your Lordship, then let me make a call then, maybe. Yeah.
Yes.
If the petitioner,
If you are insisting,
If the matter
or
may
we
be
can
taken
take up on
after getting instruction telephone.
or we can take up in the afternoon also.
If that can be done, Your Lordship,
after the matter.
I'll be obliged to you. Lordship.
After the matter is over. Okay.
I can just make an.
And we'll take it up as a
Whether
last
the bail
item
has been
today.
cancelled or not, whether bail bond has been taken.
Whether the bail was, whether, only the question, whether the accused was arrested or after arrested, whether he was released, whether that bail was cancelled.
That I have to inquire. Lordship.
Okay. After some time, huh?
Orders, item number 19.
Mr. Lordship. Lordship, I beg to mention on behalf of the Human Lordship.
Okay.
With 2 weeks time in the continuity. And for respondent number 1, Lordship.
Lords,
Lordship.
I am appearing for the petitioner in this case. Lordship can hear me?
Yes, just a minute. Affidavit with regards to justice service. You are for?
I am for my lords, the petitioners in item number 19 and 20.
19 and you are for?
This is our. Your Honor, we are the petitioners.
Your counsel is there?
Yes, Your Honor.
Okay.
Oh, I'm so sorry, Your Honor.
That's okay. Okay.
My apologies.
Yes. Dusty, you are on item 19.
Lordship. I was appearing for them only. I think there is some confusion about the item number. I will recheck and come back, my lords.
Okay. We are on item 19. E.N. Kitan.
Yeah, Lordship, I represent the petitioner, Lordship.
Mr. You are Mr.
NZ Lothar, Lordship.
N.J. Lothalani, counsel for the petitioner. Applicant, huh?
Yes, for the applicant, Lordship. Does this service has been completed?
Okay. Mm.
And I filed an affidavit in this
After
regard.
quoting service upon the respondent.
Lordship.
The respondent number?
2 and 3, Lordship.
By way of Dusty service, the applicant has filed affidavit to that effect, showing that he has taken steps upon the respondent number 2 by a Dusty service. Where is the receipt of the
Receipt of the justice service has been annexed as Annexure 1 and Annexure 2, Lordship.
Okay.
Yeah.
Okay. In the affidavit with annexure?
1 and Annexure 2.
Name and signature of the receiver. No name, only signature.
It is the IO, the inspector, Lordship. It is the IO, the inspector of the respondent who has received the notice, Lordship.
Okay. Now file affidavit as a proof of as a proof of notice upon the respondent. Start seeing the affidavit along with the annexure. 1 and 2, where there is the respondent has, but there is no name.
Lordship, the
This is
Lordship
signature of the inspector.
Yes, the Lordship may put on record that Basil Pet IO has received on behalf of the respondents.
IO?
Yes, IO. The IO, the name is Basil Pet, P-Z-U-L-E-P-E-T.
Yes, yes. I thought this is something else.
Lordship.
Then he is inspector.
Lordship, he is the IO.
And then another is a Lok Ayukta.
Yes, or the border.
Lok Ayukta, whether inspector can receive.
Lordship, I was told that they can receive the notice on behalf of the.
I have no idea because this is, the notice is the address is Nagaland Lok Ayukta.
Lordship.
So it's secretary, but then receipt is by inspector of Nagaland. Okay.
Lordship, it is it is within the same establishment.
Inspector of Lok Ayukta.
Lordship, the establishment is within the it is within the same establishment, Lordship.
Okay.
Lordship.
Okay, which is received by which was received on 28 February 2025. However, no one appears on behalf of. How many respondents are there?
3 respondents. One is the state, 2 is the Lokayukta and the IO of the Lokayukta, Lordship. The Directorate of Nagaland Lokayukta.
Yes.
Lordship.
Okay. Anyone represents after hearing, hard and so and hard name is King, for the respondent number one, stop, then that will count. However, no one appears on behalf of the respondent number 2 and 3. What is this matter about?
The matter relates to question of proceedings, Lordship, of the Nagaland Lokayukta on the basis that the FIR has been registered without any process following the process of law, Lordship.
Question of proceeding.
Lordship, question of proceedings of the Nagaland Lokayukta against the petitioner, Lordship.
Well, a notice was issued.
Yes, Lordship, notice has been issued on 18.
Did not issue notice, You have
Lordship.
taken steps.
Yes,
But
Lordship.
then
None appeared to
order,
Lordship.
it doesn't reflect that notice to be issued.
Notice has been issued, Lordship.
Yes, but only says. It is
Yes.
assumed it appears that notice was issued, but then notice says that notice is made returnable.
Lordship, notice
But then
is
you
made
have taken
returnable
notice
within 4
directly
weeks.
by way of dusty service.
Lordship, the Honorable Court is directed in the last
Okay.
occasion like that, Lordship.
So you want to file affidavit?
Lordship.
Okay. Ms. Cheng, prays for 3 weeks. 3 weeks. 3 weeks time.
Lordship, may kindly make it 4 weeks because on the 3rd week I will be in Delhi, Lordship.
Okay.
Mm.
Pray for some time to file, obtain instruction and to file affidavit stuff. Is prayed for by both the Land Council for the party. List this matter after 4 weeks.
Lordship.
Much obliged.
Much obliged, Lordship.
Orders, item number 20 and 21.
Your Lordship, please.
Yes.
Lords, I am appearing for the petitioners in this case. Lords, it is a case where, Lords, a small newborn girl, my Lord's child, she suffered a brain damage in the hospital and she has gone into a permanent vegetative state. Now, my Lords, the parents who are before my Lords had filed a writ petition. That is writ petition number 6. My Lords, unfortunately, the counsel for the petitioner, the erstwhile counsel, she withdrew most of these prayers by forging the signatures of the petitioners, for which, my lords, the application has been filed before this honorable court. Your lordship will have the details of this application, which was recorded in the order of 11th of November 2024. Lords, thereafter, we were given the permission to file our rejoinder also after they filed the reply, and now the pleadings are complete. So, my lords, in sum and substance, Lords, I can demonstrate from the records that this application was filed with a forged signature. The Wakalatnama, which was there on record, was also tempered by the council, respondent number 7 before this court now. And there is a complete forgery committed, for which this honorable court needs to take cognizance and decide whether, my lords, the liability should be fixed on the respondent number 7 and whether I am entitled for my prayers back, which I initially filed before this honorable court.
You are
Lords,
on IA.
IA 65, my lord.
IA 65.
Yes, my lord.
21.
Of 21, my lords.
No. Not 20. This is IA 21, 25. Where is IA 65? Okay, IA 65. IA 65 is for what?
Lords, my erstwhile advocate My lords, she forged my signatures and withdrew all the relevant prayers from the writ petition. And this is how, my lords, my rights
Just a
in the
minute,
petition.
whether this is IS 65, you are IS 65 or in some other case also, there are some, what is IA 58?
IA 58 is the restoration of those prayers which
Okay,
have been.
What is this IA 21, which is been listed today?
My lord, I am appearing for the applicant.
IA 21?
Yes, yes.
What
Yes,
is this matter? What is this matter about?
I will brief you, sir. Model. There is an interim order given by this respectable court in 2022 to continue the treatment for the baby, Aldrina.
But she's on the ventilator support.
1 minute, let me. We are giving continuously the treatment to the baby now for the last 4 years. Now, in the writ petition, original writ petition, there were so many allegations that there were negligence, there was a problem because of the hospital only the problem came. It is contagious disease, etc., 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 which is not correct. Now we are filing this in IA to modify the order dated 18/2/2022, my lord. Kindly, my lord may kindly turn order number 18th February 2022.
Have you annexed in your IA?
Yes, my lord. I will read the operative portion, my
Have you
lord.
annexed the said order in your IA? Just a minute. 8/3. What did you say? Date of the order?
Date of the 18 February 2022. There's a first order issued by the respect.
Just a minute. You have annexed 8/3, not 18.
Sorry, very sorry, my lord. 18. It's
The
18.
annexer 8/3.
No, we are going to.
No, not the 8/3, which you have annexed.
Not the 8/3.
Not the 8/3.
18/2/2022.
This IA is filed in
Christian Institute of Health Science and Research Hospital.
Where do I find that order? 18/3, 18/2.
You can find from the original writ petition, my lord.
With petition number?
6 of 2022.
6.
Yeah. Yes, my lord. It's the first order issued by the respectable court.
It was not a first order, it appears.
Yeah, this order against our institution.
Yes, 18/2.
Yes, my lord.
18/2.
Lord, may kindly see the petition, page number 6/7. 6/7. Last line. Respondent number 1, shall I read?
Just a minute. Page number 6.
Yeah. Yes, ma'am.
Yes.
Last paragraph, last 2 lines.
Page 6 is
Respondent number
the
1
last
shall,
page. Page 6 is the last page.
Yeah. Respondent number 1 shall continue to provide.
No, it's not there. 6 is last page.
Here it is 6/6, 6/7. Yes, 6th only, last.
The paragraph start with?
On the basis of the law as laid down by the Honorable Supreme Court.
On the basis, yes, it's page 5, yes.
My lord, last two lines. Respondent number 1.
Where? On the basis of the law as laid down.
Supreme Court in the above mentioned judgment and taking into consideration of the present need that the child in question requires continuous treatment, this court is of the opinion that till the next returnable date, the respondent number 1 shall continue to provide present treatment being meted out to the said child. The entitlement of the respondent number 1, page number 7, my lord.
Yes.
The entitlement of the respondent number 1 to the amount as claimed in the legal notice as well as the treatment meted out to the child of the petitioner shall be considered on the returnable date.
Okay.
My lord, this is based on the Supreme Court judgment entitled, the title is Paramananda Katara versus Union of India. It is mentioned here also, page number. Page number 5, para number 66. In Paramananda Katara, yeah.
Yes.
In short, I will explain the Paramananda Katara case is related to emergency treatment for any citizen who is in need of emergency care in an hospital without demanding any money. This case, Paramananda Katara, a person was injured in a road accident and he was admitted in an hospital, corporate hospital. The bystander gave 3,000 rupees for his treatment. They give all life support. They demanded further money. The moment the person is not able to, the person is a bystander. The moment he was not able to pay, they removed all the life supporting equipments. The fellow died. Case is out of an emergency case. Now, on this basis, we got an order from this respective court to continue the treatment. We are not continuing the treatment. But my submission, my lord, is very important fact has been omitted in the writ petition. Because the baby was born, premature baby, out of 38 weeks of duration. That's the gestation period, my lord, for a normal baby, 38 to 40 weeks. This baby was born on 30 weeks only, 30. My lord, average weight of a baby in India is 2.5 kilos to 3.5 kilos. This baby was only 1 kilo, 100 grams when it was born. Naturally, my lord, when such babies are premature in such a way, organs is not, they are not grown properly. So infection is about to come. My lord, as a very, very careful way, we protected the baby, and also we have not claimed, when we want to claim money, they got the order from the High Court, so we never demanded money. Now, the High Court has asked the All India Institute of Medical Sciences, Delhi, whether to shift the baby for a better treatment. The AIMS report is also enclosed in the IA, my lord. They have got a video conference, they collected all the medical records, and they found that it is very risky to transfer the baby and let the CSHSR give the same treatment. My lord, it is my humble submission. I am a very pakka private mission hospital. I am not from government side. It is a fact that the hospital was promoted by 3 agencies. One is Government of Nagaland by giving lands on lease basis only, not free, no donation. Lease basis, we got the land from Government of Nagaland. CMC Vellore, they gave all the medical help. And EHA hospitals in Delhi, they are having 21 hospitals in North India. They are helping us to send our doctors for training and sponsorship. But I am 100% private hospital. My lord, quickly I want to brief you because the baby was premature and the writ petitioner, number 1 and number 2, they have not approached the court with clean hands, my lord. My lord, they never revealed that the mother of the baby was also gave a premature baby earlier. She got a cervic cancer earlier. She is a foreign national and they have suppressed everything and they approached this court and got this order. However, We 100% respect the order of the High Court. My lord, due to time, I want to brief it. Now it is more than 4 years, my lord. And the expense is 1 crore and 30 lakhs, my lord. We are private, we are very, very average institution. We were started only 15 years back in a hill area of Dimapur with the help of many agencies, Christian as well as government help. We are not getting any funds from help from government or any central government or state government or foreign nationals. We are standing on our own lone legs. Now, my lord, it is a huge amount for us. The last thing I want to inform the court is, my dear friends, if we peel away the emotional things in this court, in this case, if we peel away the emotional aspect of this case, what remains is a contract between patient's parent and the hospital. And hospital is giving medical care to the baby.
Okay, just a minute. Sir.
Parents
Just
are...
a minute. Who is appearing for the respondent here? You have filed for modification of the order 18.2. So who is for the respondent? Yeah.
Your Honor, is
Not,
in IA
obviously
21.
they have made us the respondent.
Just a minute. In IA 21, who is for the opposite party? Respondent. Christian Institute. Ganguly, Barbara Nunez, Principal Secretary, Nagaland Medical Council. Who represents the state, the union, All India Institute of Medical Science, Tejanguli, you are Tejanguli, you are respondent. So they have filed this application for modification of the order,
Yes, sir.
earlier order.
Your Honor, I would like to reply
Can I-
2 things.
2 weeks.
No, Your Honor, I would like to say 2 things.
Okay, you have filed reply to this.
No, Your Honor.
Notice is yet to be issued.
Are you engaging any advocate?
Yes, Your Honor. Yeah.
Who? Okay, so you are filing a objection or any affidavit here?
Lords, and your lordship is yet to issue notice to us in this matter.
Notice not yet issued in this case.
My lord,
Yes, no.
Your Honor,
not
if I
appeared
may.
earlier, not appeared. The petitioner appeared in person.
Lords, what has happened in this case?
Who is the petitioner who appeared in person?
Lords, can I explain? Lords, what the the institute has done, they have filed a case with a different name. Instead of filing an IA within the same writ petition, they have given it a different name by keeping themselves as a petitioner. Lords, they got it listed on a different date, and also 3 dates this matter has been listed on a different dates, and we are yet to be
Mr.
issued
Posek,
notice,
your
formal
applicant here.
notice.
Lordship, I'm for the applicant.
Okay,
This is
okay.
Mr. Abraham.
No, whether
Mr.
notice.
Samuel.
stay
Lordship,
for-
we have served copies to all the parties, Lordship.
Is
Your
it?
Honor, that's not true.
No notice was issued.
Lordship,
It
in
appears.
fact, Lordship, the petitioners, the right petitioners here, they're now represented by a council. So if the petitioners may kindly sit down, let the petitioners.
Lords, it is not, we are not disputing that, but your lordship have yet to issue notice to us. So that we can
Listen,
file,
sir.
we can respond to this.
This
What about
This
copies to
IA
Ames?
Notice was.
Lordship, may I please Lordship,
Sir, when the respondent.
this IA is arising out of the lead petition.
Okay,
So when an IA, a connected IA, Lordship,
yes,
we have filed the IA and we have served copy to all the parties. Lordship.
okay.
And this honorable court was pleased to serve notice upon the respondent
So,
7 also.
Okay,
And we have taken steps on respondent 7. That is the aims.
No.
have you received the copy? Have you received the copy? Have you received
one
the copy?
submission, my lord, one submission.
Just a minute. Have you received the copy, Mr. Who appears for the respondent? Private respondent, have you received the copy? You have received the copy? Copy of this application? What do you have to say? Are you filing affidavit? What is your?
We will file our reply, my lord.
You'll file reply?
We will file our reply, my lord.
When are you going to file reply in this?
My lord, your lordship will allow
Order
us
was
to
passed way
file.
back in the year 2022.
No. This is a fresh application, my lord. We have filed.
No. Order was passed way back in the year 2022. And they are filing this application now, 2025.
Yes.
For application with said order. Are you filing any affidavit here?
My lord, we will file it.
Okay. So
My lord,
probably
can I make one
earlier, because you sought for some time, no one appears. On 2 occasions, this was party wanted this matter to be listed on next date. But then on the next date, notice was noticed, but then copy was served. The learning council for the applicant shall take steps. You were directed to take it. Have you taken steps?
Yes, Lordship.
Okay. So you have received copy. Okay. Mr. Poseko Pote, learning council for the applicant. Stop. Mr. You are Mr.
Sachin Jain.
Sachin?
Jain.
Jain. Learning council appearing on behalf of respondent number 1 and 2.
Lord, I'm sorry, I don't have the memo. The clients present in the court will be able to assist my lords on that.
Yes. 1 is Mr. Tejanguli. 2
And
is
2 must be Barbara.
Ms. Barbara Nunes.
Lords, we kindly mention that they are also present in the court.
Okay. The respondent, Ms. Tejanguli and Mrs. Barbara Nunes are also present in person before the court. The and praise for how much time it will take to file reply?
Lords, 3 weeks is fine.
Praise for 3 weeks time to file reply. Stop. And who appears for the Ms. Sukri, the additional advocate general? You have received the copy? Okay. Okay. On behalf of the state respondent number 3 and 5. And who appear for the medical council?
Lordship, they have never been represented.
Hmm?
They have never been represented, Lordship, in the previous case also.
Okay.
In the previous corrected.
And Union of India?
Union of India is represented by Mr. Gauhati.
Okay.
Observe the copy.
So have you taken a step upon All India Institute of Medical Science?
Lord.
Why this has to be included?
Lordship, this is a party in the read.
Party
In the read,
petition.
Lordship.
Okay.
The read petition 6 of 2001.
No one appears on behalf of the respondent number 4, 6, and 7. You have taken steps upon them.
Lordship.
Received. Still awaited or what?
Lordship, I've served copy to Mr. Gauhati in respect of respondent 6 and in respect of respondent 7.
Okay. However,
Steps.
However, the service of notice upon the respondent number 7 is still awaited. And then this. Four and 6. 6 earlier served.
Yes,
Union.
Lord. I've served copy.
He is accepted notice. Appeared also.
Yes, it appeared also.
Okay.
Lordship, in
Is
respect of
Hmm?
my submission, Lordship, in respect of respondent 4, if I may be allowed to take another steps on respondent 4, since I'm not present.
Poseko Pote, Council for the petitioner. Praise for allowing him to take fresh steps upon the respondent number 4. And 6 also, 6. Okay.
6 have taken, Lordship.
Okay. Prayer allowed. Steps upon the respondent number 4 by a registered post with AD, as well as the usual by usual process within a week from today. Stop. para, age prayed for, comma, least this matter after
Yeah, bring for
3 weeks.
3 weeks, sir.
3 weeks,
3
after 3 weeks. Okay, this is.
Your Honor, if I may just say two things in regards to this IA 21.
Yes, what you want?
First thing I would like to say is to clarify exactly what they are asking for, which is to take my baby off the ventilator.
You have given an opportunity to file affidavit.
And second of all, I would also like to update the court that lately, for the past few months, the baby is once again acquiring multiple hospital-acquired infections due to a lack of proper hygiene. The hospital has also.
No, probably you are not paying the hospital bills.
It doesn't mean that they can give her infections and risk her life, Your Honor.
Yes.
Your Honor, they are giving her infection after infection once again, putting her life at risk each time. And Your Honor, they've also have stripped us of our rights to have copies of the medical records, of the latest medical records, and also of the bill. We are not allowed to see the bill. Every day the bill is being added,
Why?
yet they don't let us to see the bill.
I think this fair enough to furnish a copy of the bill as well as the medical records to the mother.
By submission, my lord, we are ready to submit all the copies of medical records, number one. Number two, nowadays they are not coming and taking care of the child at all. They never visit. Once upon a time, they visited and they harassed all the doctors and nurses in such a way. Our institution is very, very good institution, calm, quiet, continuously giving treatment on par with the treatment to be expected from AIMS Delhi. AIMS doctors gave an opinion that the treatment was very good. It can be continued in Dimapur itself. Don't shift the baby there. Now, we are free that if they intend to shift the baby, we are ready to shift the baby. But she has not consented the letter to shift the baby in a higher authority or higher profile hospital. She is not giving a way this side or that way, just taking a foreigners as taking a judicial thing as her own whims and fancies. My lord knows very well. Claiming compensation in a writ petition is not possible. They have to go to a trial court. Now, as a legal jurial person, my lord, irreparable loss was caused to us. 1 crore 20 lakhs is a very huge money for my hospital, my lord. We are giving mission hospital. Mission hospital, there is a difference between mission hospital and corporate hospital, my lord. Mission hospital, our aim is serve the society. Attendant factor is income. In a corporate hospital.
Just a minute. Who is to pay the bill?
Parents are not paying the money. They are not paying money. They are there.
Can I just respond, Manoj? What has happened? Look, the child was born healthy. The child suffered brain damage because of their negligence. The child went into vegetative state at their hospital, and by this honorable court's order, they are supposed to take care of the child, my lord. There is nothing strange about it. After all, they have caused the brain injury. We are always at loss. We have lost our child.
Okay. My lord, I explained about how it was born. It's a premature.
That is why I would
hospital. Just a minute.
That is why I would submit.
Just 1 minute. Just a minute.
Yes, madam.
So you said that you did not receive the copy of the bills as well as the
Medical
records.
Yes.
And
we have written a letter requesting it from the director. He has refused.
What?
We've written a letter directly requesting the director of the hospital for the latest copies of the latest medical records of the baby and also to allow us to see the bills, but he has rejected.
The petitioner, Ms. Nune. Not the petitioner, the respondent.
Your Honor, if I say one thing.
Submit, Nunes, appearing in person, submits that she has made a request to the applicant hospital to provide her a copy of the bills and
the medical the daily bill.
Medical records.
Daily bills and the daily medical record.
Yes.
Daily medical records, however, the medical records. The applicant shall provide the copy of the daily medical records and the bills of the baby. What is on record? She has been named as
Baby Adriana.
Baby Adriana.
okay, baby Adriana. Within a week, you furnish this copy within a week.
Your
Yes,
Honor,
my lord, I will.
Within a week from today. Okay. List is
Only
not-
one submission, my lord. Under the one submission only. Under the pretext of negligence, thereby the baby suffered, is to be tested and conducted in a trial court. And asking for negligence, compensation, etc., is not coming under the writ jurisdiction, my lord. That point, they are dodging to pay the bill. That is the only one-line message, my lord. My lord has to help my hospital. We are, as a jural person, we are suffering a lot.
Yes, yes. So let it.
We should be given the right to claim the by the civil side. We will go by the civil side.
Let them
This order prevents us, my lord. This order prevents us to go to claim the amount in the civil side, my lord.
let them file reply.
Yes, my lord.
We'll take up your matter.
Yes,
We'll consider your matter, your application. Okay. Yes. And what is next?
IA 65, Your Honor. Item 21.
IA 65.
Yes, Your Honor.
Item 21.
Yes, my lord.
65 is IA civil 65. Okay. Yes.
Lords,
I think your part is done. Your part is done, I think.
This is us, Your Honor.
This is also
Yes,
IA 65 also your party.
we are the petitioners. Yes.
IA 65, your petitioner.
Yes, Your Honor.
Who is for the applicant here? Who is
Lords,
for the,
I'm appearing for the applicant.
you are for the applicant?
Yes, ma'am.
Okay. Name is not reflected. Okay, who is for the respondent here?
Lordship, I've been implemented as respondent number 7.
You are for 7.
This IA is this wrongful complaint is made against me, Lordship. I
You are for 7.
represented the petitioners in the writ petition briefly based on pure instruction, Lordship, for a few days.
Just a minute. IA 65. C 65. This is rejoin the affidavit. Okay, here you put a petitioner.
Yes, my lords.
Institute Health Science and Research is Principal Secretary, Medical Council, State, Nagaland, Union. Okay. Where is respondent number 7? 65 in writ petition. You are the respondent number 7?
Yes, in item 5, Lordship.
Your name is not there in the petition.
Lordship,
In
perhaps
the
the
application?
applicants have not, not have taken
Whether the
steps,
petition
Lordship.
was amended? Whether this application was amended, there is no respondent number
Yes,
7.
Your Honor, I submitted the amendment application quite a while ago to the registry.
Affidavit in opposition. Amended memo. Sixty-five. Yes, in amended course title, you have included respondent number 7 also. Okay. And then who has filed affidavit in this respondent IAS 65? You have filed affidavit.
I have filed objection as directed by the court. The file
Okay,
rejoinder, then I file the
7.
affidavit again.
Who else has filed affidavit? Mr. Jose Gopote, have you filed?
No.
You have not filed.
Here,
Not required. And what about a state? Against respondent number 7. Okay. So there was a complaint against the respondent number 7
Yes, my lords.
before the bar council also.
Lords, that is on the disciplinary side, but this court, my lords, will look into this because it is a offense committed against the, my lords, the administration of justice before this honorable court.
Yes. Now, okay, what is your case then?
Lords, will see the order of 10th March 2022. In 10th March 2022.
Where? In
My
which
lords, in the main writ petition, and it is part of this application at page 331, my lords, annexure C.
Page 31. Okay, I think we have to continue at 2. We'll continue at 2.
Yes, my lords.
Yes.
Yes, what is your case? You're alleging of some forgery.
Yes, Your Honor.
This,
Your Honor, I would like.
just a minute. For the forgery, just wait, huh? For the forgery, if any, is it proper before the High Court? If you're alleging forgery. Mr. What is his name?
Sachin Jain.
Sachin.
Jain.
Mr. Sachin. Hello, can you hear me? They can't, it appears.
Honor, if I may.
Yes.
If we go to Order 18-2022.
18-2.
18-2022 of WPC 6-2022.
WPC?
6-2022.
Yes.
Page 4, Your Honor.
Yes.
If I may read.
Yes.
The learned counsel for the petitioner submits
Counsel,
that.
where? Just a minute. Where? This is not at 4. 18-2022.
Yes, Your Honor.
Page 4 is something different.
18-2022 in
Where?
WPC 6-2022.
No, it doesn't start with that. I have heard.
It starts with, is the father of a baby aged about 1 year?
It's not here. Okay, you count the paragraph because page would be different because you have obtained from the online.
Your Honor.
It starts from
1, 2, 3, 4. Paragraph 4.
paragraph 4.
Is paragraph 4 the
In
instant
WPC
repetition?
6-2022, 18-2022. Order.
Yes.
Paragraph 4.
Yes, Your Honor.
Each issue notice.
6, Your Honor. Paragraph 6, Your Honor.
Notice in respect, no.
The instant writ petition has been filed by petitioner who is the
Okay,
father.
the 7, okay, yes.
if we go further down,
Hmm.
though there has been serious allegations made in the writ petition pertaining to the negligence of the respondent number one, the doctors therein, the learned counsel for the petitioner submits that she is not pressing for relief sought for in the instant writ petition and would file appropriate application for deletion of the same. However, the only grievance of the petitioner is in the instant petition is that the baby, who is presently suffering from global cerebral atrophy, requires treatment, and since the treatment presently meted out to her by the respondent number one, she would not survive. So the petitioner's counsel submitted that the petitioner will not be going forward with the prayers in the original writ petition.
What was that prayer?
The
She's not
prayers were
praying
for
relief,
investigation. Yes, Your Honor.
relief part.
For investigation of medical
Well,
negligence.
after that, subsequently, you have filed an application
Yes, Your Honor. An application
For-
was submitted.
for,
Order date 10/3/2022. In IA 18. Date
IA 18.
10/3/2022 in IA 18.
IA 18 is not there. Let us see what is the prayer for relief in the writ petition. Okay. Issue direction to the respondent to provide adequate compensation that will be required by the petitioner and his family to take care of the baby after she is discharged. Order?
10/3/2022
Yes.
in IA 18,
Hmm.
2022. Starting from para 2.
Hmm.
By the instant application, the applicants have sought for modification of the relief sought for in the writ petition. Hereby, instead of existing relief sought for in prayer number C, the applicant seeks substitution. And then further down, Your Honor, apart from the above, the applicant also seeks for deletion.
Pass an order that I think is stated in my. The petition is stated to the. Okay, yes, apart from.
Apart from the above, the applicant also seeks deletion of the prayer so far as the prayer serial number D, E, F are concerned. So with these two submissions, Your Honor, that is how the prayers were removed without the knowledge or consent of the petitioner.
Just,
And the IAs in connection with these
just a minute.
orders.
Just a minute.
Yes, Your Honor.
D, E, and F. Have you seen the prayer for substitution?
Your Honor, in which order?
In the same order, 10-3,
Yes.
22. The applicant seek substitution of the said prayer with the following.
Yes, Your Honor.
What is this? Is it not the same?
Your Honor, the original prayers of the petition were removed by the request of the council.
Yes. Is it
without the knowledge or consent of the petitioner.
okay? But just see what is this prayer?
This prayer is for shifting the baby to Ames. That one was done with the knowledge and consent. That specific request, which is to shift the baby to Ames in
Yes.
New Delhi, that was done with the knowledge and consent of the
With the knowledge.
yes,
Okay.
under IA 17.
Okay,
But
that's-
all other IAs
No.
were forged, Your Honor.
No,
The signatures
just
of the
IA
petitioner are
IA
forged.
18.
Yes, IA 18, the signatures are
say
forged.
purportedly this, of course, the application to remove
Yes.
prayer D, E, and F, and to replace the prayer number C with this prayer.
Yes, Your Honor.
And this prayer says directing the state respondent, pass an order directing the state of Nagaland through respondent. Can you read this?
The prayer, Your Honor?
Yes, the prayer.
Pass an order directing the state of Nagaland through respondent number 2, 4, and 5 to shift the petitioner's daughter to a government hospital outside of the state, which has the capacity to provide specialized care required by the applicant petitioner's daughter,
Yes.
and to bear all expenses associated thereof
Yes. To
with
bear-
her treatment as well as transportation.
Yes. Then this, is it not the replacement of the prayer made in those?
Your Honor, in order to make sense of the matter, we
Hmm.
have to first start with the previous order, which is 18/2/2022. 18/2/2022
Yes.
in WPC 6/2022. The petitioner's counsel appeared before the court,
Which paragraph?
paragraph
That
6,
that
Your
was
Honor,
7. That was 7. The earlier which you read, the
Yes.
extent petition. Okay.
that the petitioner, the counsel for the petitioner submits that she is not pressing for relief sought for in the instant writ petition and would file appropriate application for deletion of the same.
Just wait.
Yes,
Just
Your Honor.
go to see. Just come back to your prayer in the writ petition, original writ petition. What is your prayer? D, E, and F. What is D? D is for directing to the respondent number 7 and 8 to take appropriate legal action against the respondent number 1 for the gross medical negligence. That will be at page 85 of the writ petition. Do you have the copy of writ petition?
No, I don't have it, Your Honor. I have tried to request the files from the
Okay.
oh, okay, Your Honor, it will be here in the IA. So sorry. Yes, Your Honor, I have it. The original petitions in the writ petition were as follows: A, admit this petition; B, issue direction to respondent number 1 and 2 to provide complete set of medical records associated with the treatment of the petitioner's daughter ever since her birth till date. C, issue directions to conduct an independent inquiry into the negligence committed by the respondents 1, 2, 3, 4, 5, and 6 at various occasions throughout the 3 admissions that the petitioner's daughter has been through ever since her birth, and due to which she is looking at a life of complete disablement, and therefore prepare a detailed report and place it before this honorable court for further action and direction. Issue direction to the respondents to provide adequate compensation that would
Compensation part.
require.
Okay, compensation part, it's not there. There are all expenses associated thereof with. as well as transportation. Okay, the compensation part removed.
Yes, Your Honor, the petition,
So you are insisting on compensation otherwise.
yes, Your Honor.
Okay. So these, according to you, both.
But the issue at hand with
this-
IA 65, Your Honor, is not this specific issue. The issue is that signatures were forged on IAs.
Okay, so this IA was filed
Yes.
without your knowledge.
IA 18, yes, Your Honor. In fact, IA 15, 16, 18, and 20 were petitioner number one's signature was forged, Your Honor.
Petitioner number one. Who is petitioner number one?
My husband, Your
Okay.
Honor. IA 15, 16, 18, and 20. The signatures are forged.
18 also.
Yes, Your Honor. Only IA 17 contains the petition number one's true signature, as can be seen even by his passport, Your Honor. And Your Honor, if you look at the signatures on these IAs, they don't even match each other. They're completely different handwriting. It's very clear for anybody to see that they are forged.
We do not know, but that is the dispute of fact.
Your Honor, anyone can see. Even an uneducated person can just see the handwriting that is completely different from each other.
No, that what I'm saying is that we do not know. A person, same person may also change unless it is opined by the expert.
You know, may I, that day I came and I signed all the documents which she gives.
Okay,
I did
that,
the
that day
signature.
that day you came to court.
No, I came to.
No, in her office.
Okay, you signed.
Yeah, I sent multiple documents, like around 7, 8 documents, but I did the same signature on that way. But
Yes, but these are different.
and that the one which day she gave me to sign was only to transfer my baby to Ames.
Yes.
She told me that, okay, this is the one is for that.
So why all the different handwritings? That doesn't make any sense. These were forged. They were also not communicated with us. And furthermore, opposite party number 7 has tampered with the court records. She has tampered with the vakalatnama.
Now, yes, Land Council. Mr. Just a minute. Huh? Yes, can you hear me?
Not me.
Yes.
I can.
So this is an allegation of forgery. You are making an allegation of forgery. Is it not a dispute of fact?
Not, in fact, my notes, the respondent number 7 has at places admitted the forgery. I can show that. I can assist the court. If the court finds
Suppose
substance.
even if it is admitted also, what this court can do?
Lords, the first recourse is court can take action under section 340 CRPC, read with section 195.
What is that? 340?
Lords, to refer the matter to the criminal court for adjudication.
So that is why I'm saying.
That is one thing, my lords, which I'll show the law on that. Secondly, my lords, I have sent a judgment to Ms. Barbara.
Now that unless it is admitted without investigation.
So, my lords, the scope of the 340 is the investigation itself. Lordship can have 340 for a moment. It requires investigation.
Yes.
And after the investigation, the matter will be tried by a court of competent jurisdiction on the complaint of the registrar of the Honorable High Court. So that is a procedure given in the law. Second is, the Honorable Supreme Court has said that this kind of matter falls into the jurisdiction of the criminal contempt of this Honorable Court. I have sent it, your Lordship will see the judgment, please, my lords, for a moment.
Yes, para relevant.
Lords, I am just. Lords can see the head note itself.
Yes.
So, Your Lordship, this
This
forgery and
contempt, criminal contempt.
yes, my lord, it does amount to criminal contempt. Lords, how can anybody tamper with the court records? Forgery is one thing, then the wakalatnama has been tampered. May I show the relevant part, my lords?
Yes.
Your Honor, the original Vakalatnama will be there.
Page 35 is the wakalat
Page 35
of this application 65, my lords.
with petition 65.
Yes, my lords.
Page
Page 35, my lords. IA 65, page 35. Annexure D.
No, sorry. This is writ petition, WPC 6. Writ
No,
petition
no, my lords. IA, we are talking about IA 65, my lords. I'm sorry.
65. Okay.
Lordship will see page 35, my lords.
Page 35.
Yes, my lords.
Yes.
Lordship will see the wakalatnama.
IAC 65.
Yes, my lords.
Page 35. No, at page 35 is not Wakalatnama.
My lords, it's an annexure wakalatnama.
This is rejoinder, sir. This is rejoinder.
Lords.
65. Where is 65? Just a minute. This is 6 only. Where is 65? That is 55. This is 1. This is affidavit notification, and this is just affidavit. This is affidavit. This is rejoinder. Where is this? Affidavit. This is affidavit notification. This is rejoinder. This is amended memo. This is 6 only. This is also 6. Just a minute. Just a minute. Huh? What is this? Is it affidavit on service only? It is. Just a minute. This is 65. Okay.
Not page 35.
Just a minute. No, interim. This is interim application again.
Not
See-
still.
Oh,
My
IS
lords,
65. You are saying IS 65.
IS 65, my lords, page 35 is my annexure D. Annexure D is the Wakalatnama, copy of the Wakalatnama.
1, 2. It's not paginated also.
Ms. Barbara, please assist the court.
This is not It's not paginated. Just a minute, huh? After 21, there is no pagination. This is 65, right? Okay, this is 65. Page,
My lords, page 35.
see again, after 21, there is no pagination.
My lords can have 15 pages after 21, my lords.
After
I'm
20
sorry.
After 21,
15 pages after 24 is 21 should be, my lords, the Wakalatnama. Your lordship will get a copy of Wakalatnama. All others are court orders. There is only one Wakalatnama in between.
it's not here.
Ms. Barbara, can you please?
Then it's there. Wakalat Nama, this is Xerox copy of the Wakalat.
Yes, my lords. Yes, my lords.
Okay.
Your lordship, your lordship will see, Lord, this Wakalatnama, the flutes were applied when the Wakalatnama was in the custody of the court.
White truth.
And white fluid, yes, my lords, was applied, and the respondent number 7 removed her name after the Wakalatnama was in the custody of the court. It was in custodial edges. Next page, your lordship will see, page 36, a lawyer Mugda's sign has been made. Now she has said, she is from the Delhi office. She says, these are not my signatures.
Just a minute, huh? This is opposite page.
Yes, my lords, this is reverse.
This
Lords,
is
there is one signature your lordship will see of the advocate Mugda. Lord, these signatures are also forged. Now she has said
she has confirmed us that these signatures do not belong to her. Now, question is twofold, my lords. Who applied the white fluid after the Wakalatnama has been filed? And who signed for Miss Mugdha advocate when she has not signed?
So what do you want to show by this?
Lords, there is a tampering with the court records, which is very serious.
In the first page,
yes,
Mugda's name is there.
So, my lords, the name
What according to you is the other name
have been removed. The other name was of Miss Koza, who is respondent number 7.
No, this is not the original again.
We obtained a copy, and that is why we filed it. We cannot have the original. Original is with the court record. We obtained a copy and we filed it to show this honorable court.
What I'm saying is this is not original, and the removal of this fluid is also not original, not here. It's not
Your
here.
Lordship, my lords, I explain. Lords means
After removal only, it appears this was xeroxed.
no, my lords. Yes. My lords, we obtained a copy from the registry so that we can show it to the honorable court. Now, your lordship want to see the original Wakalatnama, it should be in the writ petition 6.
Okay. So now, what do you want to show by this?
Lords, the signatures have been forged, the court records have been tampered. So, my lords, action should be taken by this honorable court to uphold the sanctity of the judicial proceedings, my lords. Otherwise, my lords, it will become a precedent. Every person will come and forge and fabricate the documents of the court, and the court, they will feel as if the court.
Whether can this court come into the conclusion without inquiry?
My lords can order. My lords, I am grateful. Your lordship can order inquiry.
So you mean to say that you did not pray for the sick or pray for deletion of the above prayer?
Absolutely not. Absolutely not.
You want to continue with that prayer?
Yes, my lords.
So have you made such prayer?
Yes, my lords.
Where?
For the restoration of the earlier prayers. That is my IA 58, my lords. Yes, I have made those prayers.
What order was passed in that?
Sorry, my lords.
What order was passed in that?
My lords, pending. Both are pending. IA 58 is also listed today. IA 65 is also listed today.
Okay. So in this IA, your only prayer is to take action against the advocate.
Yes, my lord. Because that is the need of the. My lords, personally, I would not have prayed for it because it is a matter of a colleague. But the kind of my lords, the thing has been done and the prejudice has been caused to the parents of a child who is in such a bad state. Lords, I think, my lord, this court needs to take cognizance of this.
Yes, we have filed affidavits.
I have filed, Lordship. I have filed two affidavits, in fact, with proof, Lordship.
Okay.
Lordship, kindly hear me, Lordship. In this case, it is a desperate attempt from the petitioners, applicants, to criminalize me for helping them, Your Lordship. In their desperate time, they came to me saying that there's no one to appear for them anymore. I was not in their case from the beginning. The petitioner number 2 did not want me to appear in this case, in their case, in her husband's case. That's why before the petition was filed, I was dropped from the case. Then my colleagues have helped them file it. This case was taken under the head of Human Rights Law Network. We were legal consultants there during that time. During that time, there were 3 legal consultants. I was one of them. I was also given additional charge to coordinate. I was made a state coordinator to make coordination with the Delhi office. Now they approached the Delhi office. Now what happened was, I don't know what was happening. Once she visited my office, out of sheer concern, I was sick. I made time for her. I even gave her 2,000 rupees, even when I didn't have money, saying that to buy diaper for her daughter. I even paid, I represented, briefly appeared in this case, pro bono, Your Lordship. Pro bono. I paid for the court fees. So they said they are very poor. And now what did I do? What instruction were they giving me? My instruction is based on 18/2/2022. This court said that, clearly said that I was also present in the court observing. My another colleague from Gauhati, they were appearing. They came and appeared. This court was of the opinion that medical negligence, you go to consumer forum or civil court, because this court has no jurisdiction. And so the order is very clear. These are judicial orders, Your Lordship. Order dated 18 February 2022. It says here, as far as the information that I received was that they approached this court because they said legal notice was issued by the hospital saying that if they don't pay their pending bills, then they will initiate civil or criminal action against them. This is already being taken note of by this court on 18/2/2022. When in the last paragraph it says, as regard the legal the entitlement of the respondent number 1 to the amount as claimed in the legal notice, as well as the treatment meted out to the child of the petitioner, shall be considered on the returnable date, Lordship.
That is
18/2/2022. Lordship, page number 66 of my affidavit, Lordship.
Yes.
Yes, this court has made it very clear, and the council also submitted that if the hospital discontinue the treatment of the baby, then the baby will die. It's already recorded, Lordship. This court has said that it is not necessary to implicate the doctors. The petitioners wanted in the writ petition, they wanted to penalize the doctors, also take appropriate action, and then also against the hospital. Now this court said those things are not necessary party. Then accordingly, the prayers have to be deleted because this court said Article 20, we're only concerned with Article 21 of the baby, regarding the treatment of the baby, because they said they were very poor, Lordship. And the same was accordingly, Lordship, kindly come to there are numerous email communication that took place, Lordship, whereas I was just a sidekick in this case. I was never given the case, but on 7 March 2022, my colleagues from Delhi, along with the petitioners, through the Zoom meeting, they instructed me to appear, along with the council. Mugda, then Olivia, one of my former supervisor from Human Rights Law Network. They instructed me to appear saying that Ireland was facing financial constraint. We cannot, it was during COVID, Lordship. 2022, it was COVID was there. Travel restrictions was there. So they instructed me because the case was listed next date, 8th of March 2022. I appeared from 8 March 2022 till 15 March 2022, Lordship. Only a few days consecutively, Lordship. I was very sick, but still yes, my mistake was I got very emotional considering the condition, the health condition of their daughter. Now they're criminalizing me, punishing me for I have not committed any offense. Under what offense under the Indian law are they going to punish me? Is using correction fluid and the a punishable offense in India? There's a general exception under the Indian Penal Code. I will take you to your Lordship during the later part of my argument, Lordship. There's a general exception. Lordship, even if they see it, I am saying in my affidavit, clearly stated, I have not forged a signature. My agreement with them is that I will only enter appearance for a few days during the time when the condition is not improved, when the financial situation is not improved. Then my colleagues were the one filing it. And now in the affidavit, they're saying they want to make me vicarious liability on the action of my colleagues. My colleagues also have not committed an offense, any offense for that matter. Petitioner number 1, he himself has stated he came to my chamber and then appended a lot of signatures. He stated that we had their consent. Everything was updated to them. Now, for 2 years, they were pursuing. What order did I got for them, Lordship? On 15 March 2022, this court has passed an order to airlift the baby out of the hospital because this court also, was very conscious because they cannot force the private hospital where the daughters are lying for the last how many years. They cannot force a private hospital without payment. So what they did, this court was also very compassionate. That's the day of the day, even during the COVID, the matter was heard. And then they passed an order to airlift the baby and to treat the baby at AIMS Hospital. And all the expenditure is to be borne by the state and the central government, Lordship. This was my instruction. My instruction was never to appeal order dated 18/2 of 2022. Why this order, the course of the petition shifted? Was there? Did they mention in any of the period? They have given me instruction and then I did not act. Was there any deficiency of my service for them, Lordship? Now, what offense have I committed? It's a desperate attempt to criminalize me for no wrong that I've committed, Lordship. Till date, I have not initiated any legal action against them. Because I was thinking that these people also repent. Then I swear before the God. God is my witness. I have not done anything wrong. In my entire profession, I have never forged any of my client's signature. My colleagues have also testified regarding that. Lordship, kindly turn with me to the second affidavit that I filed, Lordship. The second affidavit that I filed, Lordship.
Second affidavit, rejoinder.
Lordship, yes, rejoinder, Lordship. This is the counter affidavit, Lordship. Affidavit of position / counter affidavit. Page 19, Lordship. This is a statement given by my colleague, my former colleague, Lordship, who was also one of the legal consultants of Human Rights Law Network.
He has given this statement where?
Yes,
Where?
in page number 19, Lordship. Page number 19. It's not a bulky affidavit, Lordship. It's page number 19.
Page 19.
Yes, Lordship. Allow me to read it. To whom it may concern.
To page 19 of rejoinder.
No, Lordship, my counter affidavit in position, Lordship.
Affidavit in opposition, page 19.
19, Lordship.
19.
19.
Yes.
It says to whom it may concern, Lordship.
Where? No, this is
Page number 19 of my second affidavit.
second affidavit.
Yes, this is a counter affidavit against a rejoinder filed by the applicant's Lordship.
No, just a minute. Page 19 of affidavit in opposition or rejoinder?
It's affidavit in opposition. I filed it as / counter affidavit, Lordship. To the rejoinder. To the rejoinder.
Okay, to the rejoinder.
To the rejoinder.
To the rejoinder.
Lordship, yes.
Just a minute. Look on. Okay.
Page 19, Lordship.
Yes, to whom it may concern. What is
To whom it may concern, this is a statement issued testifying. I, Mr. K.R. Kachimi, hereby attest the following.
Who is he?
He was one of my colleague, Lordship. They know him. Applicants know him. In fact, they were contacting them only, not me, most of the time.
He is also advocate.
He is an advocate. He was one of the legal consultant. During the time, this case, we assisted them, Lordship.
Yeah.
He can be summoned before this court also, Lordship. They're willing to testify.
Okay, he was also one of the legal counsel.
Yes, they are the key witness. He and my another witness, these are my star witnesses, Lordship. Kindly allow me to read. I, Mr. K.R. Kachimi, hereby attest the following. That during the time when the case of writ petition C number 6, 2020 was instituted, I was also one of the legal consultants of Human Rights Law Network Nagaland chapter and was working with Ms. Nitya Koza, who was the state coordinator then. I bear witness to the good character and professional conduct of Ms. Nitya Koza. Under her representation, Ms. Nitya has provided pro bono services to numerous unrepresented citizens in India with integrity and good faith. During my association with Ms. Nitya, I have not seen any instances of document forgery or unauthorized use of client signature by her. Particularly when writ petition C number 6, 2024, it should be read as 22, was instituted, the client was constantly communicated of every step through various communications like email, phone calls, WhatsApp messages, meeting client at the office, and also to the extent of meeting the client in person at our own expenses. All steps of applications were moved through the instructions and permission of the client, and after thorough deliberation with the senior associates at Delhi and Assam via Zoom meeting and email communications, and that I have not observed anything done in malice or without the permission of the client. Now, these people are the ones who were filing, helping assist them in filing. Now the question is, if at all they agree, why did I have not included them, Lordship, but targeted me? When they know I'm innocent, they themselves know it. Page number 20 is another statement issued by my former colleague who was the one who filed the writ petition.
Who filed the?
Writ petition, Lordship, helped them file in filing, assisted them filing.
WPC 6.
Yes, Lordship. And also some of the IAs. In fact, they were not very transparent because while filing the application, everything was done in a hurried manner, Lordship.
He was also one of the
She,
legal
it's a she,
Okay,
legal
she was
consultant, legal consultant. She was the one who filed the writ petition, assisted them, Lordship. And even some of the IAs, she filed it. It's there, but they have suppressed the material fact also. I have enclosed it in my affidavit. Who has filed it? We are supposed to, if we haven't served a copy, then we're supposed to start undertaking.
At the time of filing or dealing with the matter, you were not the only advocate
No, Lordship.
appearing on behalf of the.
I was dropped from the case, in fact. I was dropped from the case. In fact, my presence came on 8 March 2022 only, based on in their desperate moment. Otherwise, I would not have appeared. I mean, they have harassed me so much. Their tone was so intervenous. There was never a request that has come from them. Now, Lordship, allow me to kindly read page number 20. To whom it may concern, I, Ms. Kikru Fuka, do hereby state that I was one of the legal consultants in Human Rights Law Network Nagaland Unit till the month of March 2022. I hereby attest that Ms. Nitya Koza bears good moral character and professional conduct. Under her representation, Ms. Nitya Koza has provided pro bono services to numerous unrepresented citizens in Nagaland with integrity and good faith. During my association with Ms. Nitya Koza, I have not observed any instances of document forgery or unauthorized use of client signatures by her in IA number 15 of 2022, 16 of 2022, 17 of 2022, 18 of 2022, 20 of 2022 in connection with writ petition number 6 of 2022. And also regarding the Lordship, regarding the Vakalatnama, tempering the Vakalatnama, here in page number 21, I sought an email. Through email communication, I sought clarification from Ms. Kikru. It's in page number 21, Lordship. This is my email. Dear Kikru, I'm writing this email to seek clarifications regarding the allegations made by Barbara and Tejangal in writ petition number 6 of 2022 and IS 65 of 2024, wherein they made wrongful allegations that I have tempered Tejangal's Vakalatnama by removing my name, Aka in your name, using white correction fluid. They also allege that I have forged Mugda's signature in the Vakalatnama. You are well aware that these allegations are wrongful and are not true. After I was dropped from the case due to Barbara's raising issue of conflict of interest, I instructed you to strike off my name from the Vakalatnama, respecting Barbara's desire. Respecting her desire, I requested her to strike off my name from the Vakalatnama. I have not appended my signature there because it was not even filed, which I believe you subsequently did it in good faith. I humbly request you to clarify on this matter to enable the truth be placed before this court, the court in the interest of justice. I'm also marking Arka in the mail if he has any comments to make on this matter. Now she promptly responded saying, Dear ma'am, regarding the clarification of removing my name, yours and Arka from the Vakalatnama and forge of signature, we have not forged anyone's signature. Due to the continuous harassment from the client, we have removed our name and signature from the Vakalatnama. As Mugda was the leading counsel of this case, the registry have directed to write at least the name of the advocate who will be leading this case, without which the case cannot be admitted. Her name written with her consent, as well as in good faith, but we have never forged her signature. With regards, Kikru.
Okay, due to the continuous harassment from the client.
From the client, yes.
We have removed our name.
Yes, before filing, Lordship. That is before filing.
This is not possible.
And signature from the Vakalatnama.
So she said, Lordship, then go summon her, Lordship. Summon her. No. Why is she not included in this case?
Lords, this is
there
a
any
very
law? Is there
unfair
any
statement. Unfair
is there any law in
statement.
India making a person vicariously liable, criminal liability? Did I instruct them?
Where do we find that it was removed before filing? Due to the continuous harassment from the client, we have removed our name.
Yes.
Signature from the Vakalatnama.
As Mugda was the leading counsel of this case, she was the leading counsel. If you see the email, everything instruction was done by her through with the instruction from the clients, with the petitioners. So she's saying that she has, since Mugda is the leading counsel, will be leading the case, without which the case cannot be admitted, her name written with her consent. With whose consent? Mugda's consent.
Okay. So it appears that there were 3 advocates appearing on your behalf.
No, Lordship. No, Lordship. This was before the matter was filed, before the writ petition was filed, Lordship.
Okay, no. Now this letter says that remove your name, tree of your name of the tree.
Your name is my name, Lordship.
Hmm?
Your name here means my name.
No clarification. Removing. Here you see who wrote this letter.
This email was written by me seeking clarification.
Kikru.
Yes.
Kikru wrote removing my name. Kikru's name also.
She herself removed her because of the harassment from the client.
Yours.
Yours, because I have instructed her to strike off my name.
Arka.
Yes. Now, by doing this, is their case affected, Lordship? What is the grievance? What is the actual grievance? Now they're saying that in their affidavit, they say that I have, with my personal interest, I have done this. Have I benefited anything from this case?
So your simple case would be that due to some misunderstanding, because they say that due to harassment of the client.
We object to that. There has never been any harassment.
I can.
Yes, it's not harassment.
Maybe, but an allegation. You have made some allegation against them, and they have made some allegation against you. So because of the harassment, it appears that name was.
No, Your Honor.
Now we do not know who removes. Exactly.
No, Your Honor, that's not correct, Your Honor. Even the order of this court, 10/3/2022, 2 months after the filing of the case itself, she was still appearing for us. So for her to say that she appeared only a couple of days, that's not true. She was doing our case for months since
That is a
2021.
lie, Lordship. That is a lie. But
no, that can be clear.
But the issue here is, Lordship, the issue here is what are they aggrieved with, Lordship? IA 15 is for the implement of Union of India as a party. How did it affect them by implementing Union of India as a party? Union in order was passed against Union of India to bear expenses, Lordship. IA 16 is initially for removal of the prayer. There, I can prove, Lordship. She herself has seen everything, Lordship.
Your Honor, the issue is forging signatures, canceling court records.
March 2022, it said that this IA has to be withdrawn because it is not in line with order dated 18/2/2022.
Your Honor, if I may speak.
Please allow me, Lordship. Then let them come back, Lordship. Because you're confusing this court over and over again. IA 17 was for transfer of the baby. Now these are all filed to facilitate the treatment of the baby only.
IA 17 we were aware of.
No, they don't have, Lordship, please understand this dynamics here and their intention here. They said they're not agree with IA 17 because IA 17, this court has passed the order. But how was this IA 17 came to be passed? It is because of this IA, the other IAs were filed for facilitating the treatment. Now, the prayers have to do it. It was very much in their knowledge only, Lordship. Everything was in their knowledge. In fact, Lordship, when 2nd April 2022, I sent an email saying I cannot assist them anymore on health ground. This court has appointed a legal aid counsel for them, Lordship. This court has appointed a legal aid counsel for them.
When?
22 of April 2022.
By any order?
Yes, there's an order, Lordship. Order dated 22/04/2022 is in page number 124 of my affidavit, my first affidavit, Lordship.
Order dated page?
Page number 124 is the first order, is the first time they appeared in person after I have withdrawn. I have stopped assisting them. Now, they themselves have come to the court and said the petitioner in person, along with his wife, that is the mother of the child, Page number 124, Lordship. They jointly submitted that they have been informed that the earlier counsel has withdrawn from the case due to health issues, Lordship. They're talking about me. The petitioner in person submitted that he is not in a position to engage a counsel of his own due to limited resources. In view of the above, the registry is directed to appoint a legal aid counsel for the petitioner for amongst the panel of legal aid counsels. The appointed legal aid counsel be given a copy of all the relevant papers filed before the court. I don't know whether the registry is given. They must have given, but I was told that the counsel himself has come to my, it's not my chamber during that time, Lordship. It was the office of the Human Rights Law Network. He himself came and then took the documents, which is not denied, Lordship. He has also issued a statement regarding this. Now they're making allocation. I've withhold their documents also. And the following, Lordship. This is the continuation of what has been pursued, Lordship. On 28, the following next date, on 28/04/2022, the order was passed. Mr. So-and-so, Mr. Mua Jamir was made a legal aid counsel, Lordship. Even here, the question talk about was transferring the baby. Nowhere in they ever mentioned for the last 2 years that I have forged the signature or I have deleted the prayers without their consent. They have never raised this issue. Do advocates have the power to delete prayers? If that is the case, Lordship, the litigants will not be coming to the court. Go to advocates, let the case be resolved.
Your Honor, the
Where do we
order
have
is
the
very
power,
clear.
Lordship? Where do we have the power?
The order is very clear, Your Honor.
Where is the appointment of the legal aid counsel?
Your Honor, the core issues at hand today.
Come, Lordship, allow me to please assist this court as an officer of the court, as a person party, as an aggrieved party here. And then let them come. They can come.
We'll get an opportunity.
Page number 127, Lordship. Order dated 28/04/2022.
Please.
Page number 127.
Okay.
Here,
Yes.
in terms of the order dated 22/04/2022, passed by this court, Mr. Mua Jamir, learned counsel has been appointed as a legal aid counsel to assist the writ petitioner. Allow me to read the other provisional part also, Lordship. Mr. Fosiko Forte, learned counsel for the respondent number 1, submits that the Zoom meeting has been taken place between the doctors of AIMS, New Delhi, and the doctors at CISHR Hospital, Dimapur, on 13/04/2022, wherein certain observations were made that, and for which reason it may not be conducive to shift the child to AIMS, New Delhi, and that the authorities at AIMS, New Delhi would be writing to the Ministry of Health and Family Welfare about the decision taken in this regard. Mr. T.B. Jamir's learned senior additional advocate general, appearing for the state respondent, submits that in view of the meeting, the question of arranging the transport for shifting the child to AIMS would only come depending upon the recommendation and decision to be made by the AIMS. Mr. Yangawati Leonard, CGC, appearing for respondent number 5, submits that one of the doctors of AIMS, Dr. Nurija Gupta, MD, DM, additional professor, Division of Genetics, Department of Pediatrics, had contacted him over the phone, and therefore the authorities at AIMS are aware of the matter. He, however, submits that he does not have any instruction regarding the decision contemplated to be conveyed to the Ministry of Health and Family Welfare. In view of the above, so these are in continuation of what? The order that I got for them, Lordship. On 15 March 2022, Lordship, this court has passed an historic order, Lordship. I have never come across High Courts passing such order, Lordship. Look at how compassionate this court had on the child. I also had. I still do today, till today. Daily, it is my prayers, and when I remember them, that God sustain her life.
Now, you first appear in the court in the case on
8 March 2022. I will come to you, Lordship. I will come to you in sequence, Lordship.
Yes, yes. 8 March 2022.
Yes,
This was your
Lordship.
first appearance.
That was my first appearance, Lordship. If you turn to page number 134, Lordship.
Of your affidavit.
Yes, Lordship. 134 and 135. I was told that on this day, Miss Mugda, the leading counsel, appeared through virtually, Lordship. Virtually.
Your name not reflected in this.
No, here my name won't be there. But I was told. I was told, Lordship. From here, I was given, from this day on, I was given instruction. Page number 134.
2022.
Yes, 7/3/2022. Here, I was told that Miss Mugda appeared virtually. This court was not happy, Lordship, and told her to appear in person, Lordship, because it's a very sensitive case. And this court was right, Lordship, because during that time, those days, even the internet problem was there. We still have issues with the internet, but now it has improved. It was COVID. We were all learning, Lordship, to use technology. Then page number 136. This here, one of my former supervisor, meaning Olivia Bang, she was one of my legal supervisor from Delhi office, Human Rights Law Network Delhi office. She created a WhatsApp group. Then through Zoom link was shared. Through this Zoom link, Lordship, petitioners, they attended the meeting along with Ms. Mugda and Olivia, Advocate Olivia Bang. And then I was instructed to appear. Initially, I was reluctant. I was very reluctant, in fact, Lordship. Not reluctant, why? Because of the experiences. I didn't have pleasant experience with them. After helping them, she didn't want me to appear, and I understood. So, yes, I was not reluctant. I was reluctant. But then, I was, as I stated earlier also, I became very emotional, considering the condition and looking at the petitioners as parents. I feel sorry for them, Lordship. I still do feel sorry for them because my religion says to bless those who persecute you. So I bless them, Lordship. I bless them. I don't intend any harm for them.
Yes, thereafter.
Then I was instructed. They record my phone call. I give them 2 conditions, saying that I will appear in your case only when you agree to not stop recording my phone calls. And also knowing them, I told them I will not be responsible for the outcome of the case because I will not be the one passing order. I will do my best as a lawyer, in my professional capacity, I'll give my best. They both agreed. So on 8, I have appeared, Lordship. Next, page number 38 is the email communication. This email communication for modification of prayer, Lordship, sent by my colleague. 138.
Your first appearance would be
on 8.
Should be on 7, I think.
No, 8, Lordship, 8.
8, there is any order?
8 March, yes, there was order, Lordship.
Where do
There is order.
Where do we find?
Page number 174, Lordship. Page number 170, starts from page number 173, 74. It's a short order, IE 15 of 2022. This is an application 174, Lordship.
Yes, it's 8.3.
This is an application filed by the petitioner for impleading the Union of India through its secretary Ministry of Health and Family Welfare as a respondent in the instant proceeding. The said application has been filed as the government of Nagaland does not have the specialties. Why they have to be filed? Because it says, the order is very clear, because the Nagaland government of Nagaland does not have the specialties to provide the treatment to the child, Adriana. And as such, Union of India, Ministry of Health and Family Welfare may be required to take appropriate steps for providing the treatment to the child, Adriana. Taking into consideration the issues involved in the instant proceeding, this court impledes the Union of India as the respondent number 5 to the instant proceedings. Accordingly, the registry is directed to make necessary changes in the cause title by inserting the Union of India, represented by the Secretary to the Government of India, Ministry of Health and Family Welfare, so and so, IS sends disposal of. In view of the order passed here.
Your name not reflected here in this case.
Yes, it's not reflected, but I appeared, Lordship. I appeared, and in the same day, Lordship, in the same day, IS 16 was also heard. Page number 166, 177.
Eight three.
176 and 77. The same day, Lordship, same day. IS 16 of 2022.
Yes.
Ms. Nitya Koza, learned counsel for the petitioner, submits that on account of miscommunication, the application for deletion of only relief C has been sought for, whereas the petitioner's only concern is the instant proceeding in regards to the treatment to be meted out to the petitioner's child, Adriana. As such, the instant application may be permitted to be withdrawn with liberty to file afresh an appropriate application for deletion of prayers as reflected in the order dated 18/02/2022 by this court. The IA stands dismissed on withdrawal. However, the petitioner is directed to file an appropriate IA for deletion of the relief sought for as admitted during the course of hearing on 18/02/2022. No, Lordship, if they haven't done that, they'll be in contempt of the court, of this court. Because this court has taken the issue, cognizance of the matter only on Article 21. Even on 6 June 2022.
Who appeared on 18/2?
18 June, my former colleague from Gauhati, Madam D. Ghosh, and one of her assistants appeared. Now, if at all they are aggrieved, why they have not implemented them, Lordship? Why only I was chosen, Lordship, picked up?
So on 18/2/2022, you were not yet in the case.
Appear, Lordship.
You were not yet in the case.
Not yet. I was not instructed yet, Lordship.
Your
But then since we're all from the same, working for the same organization as pro bono lawyers, out of concern, I was there observing.
What does this mean? The instant application may be permitted to be withdrawn with liberty.
Withdrawn because this court got agitated, saying that this IA is not in line with Order 18/2022.
Okay. And 18/2/22 says about what?
Says that it will only look at Article 21, Lordship. The other prayers will be deleted.
Just a minute.
Lordship, yes.
Okay, so respondent number 2, 3, 4, 5, 2, 3, 4, 5, and 6 are not necessary for proper party.
Yes. Lordship, allow me to kindly read the entire thing, Lordship.
Yes.
Page number 174, 150, 116 of my.
18/2/2022.
Yes, Lordship.
Six-
It's
60
already there. It's
page
already there in
66.
the court record, Lordship.
Page 66.
Yes. Heard Ms. D. Ghosh, learned counsel appearing for the petitioner, assisted by Ms. S. Betala, learned counsel, and Mr. E. Thibapom, learned government advocate on behalf of respondent number 7. A perusal of the writ petition shows that the state of Nagaland is not made a party. Taking into consideration the matter is in the entirety, this court deems it proper that the state of Nagaland should be made a party, and accordingly, this court impledes the state of Nagaland, represented by the Chief Secretary, Government of Nagaland, as respondent number 4 to the instant writ petition. This court also is of the opinion that the respondent number 2, 3, 4, 5, and 6, these are doctors, Lordship, who are included by name, are not necessary or proper parties to the instant writ petition insofar as the issues involved herein, and accordingly, their names are struck off. The registry is accordingly directed to rearrange the numbers of the respondents in terms of the instant order. Issue notice returnable on 7/03/2022. Mr. E. Tibapong, Learned Counsel, Government Advocate, accepts notice on behalf of respondent number 2 and 4. Notice in respect of the respondent number 1 to 3 be served by the registered post with AD along with the usual process. The petitioner is also permitted to take steps by way of dusty. The instant writ petition has been filed by the petitioner, who is the father of the baby, aged about 1 year and 3 months. The grievance of the petitioner is that on account of certain unpaid dues, the respondent number 1, which is an Institute of Health and Sciences and Research, set up on the basis of tripartite partnership between Christian Medical College, Valor, Emmanuel Hospital Association, New Delhi, and the Government of Nagaland as a charitable society and organization. Though there has been various allegations made in the writ petition pertaining to the negligence of the respondent number 1 and the doctors therein, the learned counsel for the petitioner submits that she is not pressing for reliefs sought for in the instant writ petition and would file appropriate application, Lordship, please note, and would file appropriate application for deletion of the same. However, the only grievance of the petitioner in the
Just a
instant
minute.
petition.
The learned counsel for the petitioner submitted, she is not pressing.
Yes, she
It's
is
her
not,
submission.
Lordship. This is not my submission. This is a submission made by the other councils. The learned counsel for the petition submits, she is not pressing for reliefs sought for in the instant writ petition.
See, this was on
18
18
February
February.
2022.
Just one second. 18 February, she was not your advocate.
Your Honor, at the very beginning of her speech just
No.
now.
Just a minute.
To manipulate,
Just-
Yasin, I am being engaged.
Just tell me one thing. Reply me. On 18 to 2022, she was not your advocate.
Your Honor, she just said that she was present and now she's changing her word. If you watch the live stream, you will hear her very clearly saying,
No. Just a minute.
okay, now again, she's admitting it. So she's going back and forth with that she was there, she wasn't there, she was there, she wasn't there.
Just a minute.
Are they appearing in this case?
Who is D goes?
You told Judge Kakito that you were not even in the court that day. Not even in the court's compound that day. But now you
was
clearly.
in the courtroom. I'm not denying it, but I did
Now
not
you're not
appear.
denying it. You've denied it
See,
for months.
Order.
Just a minute. No fight.
Yes, Your Honor.
See, here this submission is of Miss D Ghosh
Yes.
Your Honor,
and Miss for the petitioner assisted by H. Betala. Miss H.
Your Honor,
Betala.
Miss D. Ghosh.
Just a minute, But the court has recorded here the submission of Miss D. Ghosh and H. Betala.
Yes, Your Honor. Miss D. Ghosh did not meet with the petitioners, did not discuss the case with the petitioners at no point. All was discussed between her and Miss Kozo.
It is the absolute lie, Lordship.
That is the
Okay,
truth.
Okay, just
I have the phone records
okay.
for that, the WhatsApp records.
Okay, then let us continue with this.
Yes, Lordship.
The only grievances of the petitioner in the instant petition is.
The petitioner is the instant petition is that the baby who is presently suffering from global cortical atrophy requires treatment and sans the treatment presently meted out to her by the respondent number 1, she would not survive. The learned counsel further submits that at present there is no other hospital in the state of Nagaland which provides such treatment. Prior to this, there were 2 dates. In 2 dates, Lordship, this court has given instruction to the state government to find out whether there is any treatment facility that can be given by the government hospital. They found out, the state government has surprised this court that it's not there, Lordship. These orders are already enclosed. I have enclosed these orders also, Lordship. But it's only on record, Lordship. 10th of February 2022, 17th of February 2022.
Okay, after this, what is the next order? After this, 18/2/2022.
After this, matter was listed on 7th. I'm told, Lordship. I'm told matter was listed on 7th of March 2022. It is also reflected in the court's order 18, this order that I just read.
7.
Yes, Lordship. Page number, Lordship, it's in one fourth paragraph of the order, 18 February, Lordship.
18
It's there.
February.
Yes. 18 February 2022. The on the fifth paragraph, it says the matter be listed on 7/3/2022, Lordship.
No, 18-2 or 18-3?
18/2, Lordship. 18/2.
18-2-22.
Yes, 18/2/22.
Okay, yes,
paragraph
this
four.
one is returnable by 7-3.
Yes. So on 7/3, the matter was listed, Lordship, which I've already pointed out to the court. I received instruction from 8 March 2022.
But on 7, no any
On
effective
7, I was told your counsel, Ms. Mugda, has appeared, Lordship. This
So-
court was not happy because she was appearing virtually.
Let the matter be listed again tomorrow on 8. Okay.
Yes, so in a
This is the
hurry,
only- This is the only order passed on 7th.
yes, in a hurry, I was instructed to appear.
Now, thereafter
So I
you start-
appeared accordingly from 8, Lordship. So on 8, along with the main writ petition, IA 15 and 16 were listed for hearing. IA 15 for appointment of for implement of Union of Ministry of Health and Family Welfare, Union of India. This court made an observation that since Nagaland government does not have the facility, Union of India must be made a party. Then the court is allowed. On 16, the court said this is not in line with order dated 18 February 2022.
Okay, where is that?
Lordship, page number 177. Order dated 08/03/2022, Lordship. In IA 16 of 2022, Lordship.
170?
177, Lordship.
On the same day, 2 order was passed in 2 different IA.
In fact, 3 orders was passed. One in writ petition, which is in the subsequent pages, Lordship.
Okay. So we are concerned with IA 16.
Yes. IA 16, IA 15, which the court has included Union of India, which they are aggrieved with. IA 16, page number 177, this court clearly stated, filed an application in line with the order dated 18/2/2022. So the IA 16 has to be withdrawn. Everything was informed, even by my colleagues, Lordship.
IA 16 was withdrawn.
Withdrawn because this court said it is not in line with the order dated 18/02/2022. A direction was given.
It was dismissed.
Yes, direction was given to file an IA in line. Matlab, meaning to include all the deleted order dated 18/22 besides Article 21 to delete the other prayers, Lordship. In compliance of this court order, I still remember petitioners were very much aggrieved. I understood, but if this court says it has no jurisdiction, then we cannot press upon this court. Then IS 18 was filed, Lordship. But before we go there, Lordship, on the same day, 8 of March 2022, this court has passed an order in page number 1, starting from page number 178, Lordship. Here, which is also the hospital, I have filed an IA, which was heard before the lunch break, Lordship, for praying for modification of this the order, Lordship.
Which order?
This order, Lordship.
6.
Yes.
In order.
Petition. Order dated
WPC
same
6.
date, Lordship. Yes, WPC 6. This is a main writ petition, Lordship. 8/03/2022.
What order was passed here?
Lordship, it's a long order, Lordship. Heard Ms. Nitya Kozal, so and so, Ms. Counsel appearing on behalf of the petitioner has drawn the attention of this court to a letter dated 03/03/2022 issued by respondent number 1, wherein it has been mentioned that due to lack of neurology and pulmonology service in Nagaland, the parents had agreed for a referral to a center which offers both services and accordingly had recommended that child gets further treatment at AIMS Delhi or any other government hospital which provides aforesaid services. Ms. Nitya Kozal, learned counsel for the petitioner, submits that the petitioner at present have certain documents pertaining to the child's medical treatment, but the petitioners are not aware as to whether those documents pertaining to the child's medical treatment would be sufficient for formation of opinion for consultation as to which government hospital will be offering such services, and as such submits that a direction may be issued to the respondent number 1 to provide the document which the head of the Department of the Pediatrics and Pulmonology of the respondent number 1 considers would be sufficient for the purpose of the formation of the opinion and or consultation as regards the treatment of the child in a government hospital or any other hospitals. She further submits that though this court had passed an order on Order 1802/2022 that the respondent number 1 shall continue to provide the present treatment to the child, the order passed by this court has not been followed. On the other hand, so there was I was also, including my colleagues, also told me by the petitioners themselves saying that the hospital wants to discharge your daughter. She was in a very critical condition, Lordship. On the other hand, the learned counsel appearing on behalf of the respondent number 1 submits that the respondent number 1 is carrying on the same treatment and the protocol since April 2021 for giving the best of the treatment to the child. The learned counsel for respondent number 1 further submits that though the respondent number 1 is given best of the services, the petitioners have been harassing the nurses and the doctors. I have heard the learned counsel for the parties. A perusal of the said letter dated so and so stipulates that the child, namely Adriana, is currently undergoing treatment in the pediatric ward of the respondent number 1 hospital, and she has global cerebral atrophy and has severe neurological impairment with refractory seizures and recurrent pneumonia. It further appears that the pediatric neurology and pulmonology services are lacking in the state of Nagaland, and as such, a referral has been made to AIMS Delhi or any other government hospital which provides the aforesaid services. For the petition to find out to which government hospital will be provided such services, it will be necessary for the petitioners to get the necessary medical records of the child, Adriana, so that petitioners can take necessary consultations and or opinion as to whether the treatment of the child can be carried out. Accordingly, this court therefore directs the Department of Pediatrics as well as Department of Pulmonology of the respondent number 1 to look into the medical records of the child, Adriana, and thereupon provide a petitioner with such necessary documents on the basis on which a petitioner can obtain necessary consultation and or opinion as to which hospital of further treatment of the child, Adriana, can be meted out. Accordingly, the respondent number 1 is directed to provide the same medical records as stated here and above during the course of the day. Further to that, it is observed that via order dated 1802/2022, this court had directed the respondent to continue to provide the present treatment meted out to the child, Adriana. The said respondent number child 1 shall continue to do so, taking in consideration the best interest of the child. Now, this order did not give an absolute relief to the petitioner's daughter to be treated in the in the respondent number 1's hospital, Lordship. The concern of this court was to shift the baby so that the baby given a chance for recovery, Lordship. AIMS was what they have opted for, and this court has granted them the relief. Now, it's the council who has, in good faith, helped them. After more than 2 years of pursuing, if the matter did not succeed, then should the council be dragged in and framed? Isn't that abuse of law? Isn't that abuse of the process of court? Isn't that the concern of this court, Lordship? They have, with the same order, with the same prayer, with the same allegations, they filed before the complaint before the State Bar Council. I was made even during my holiday.
Oh, okay, there after this for removal, where is the petition? And for
IA 17, Lordship, if you have, they haven't enclosed it intentionally, but IA 17 also, I have given the front page as per the record, which is there on the court's record, Lordship. Who has filed the applications? Everything is there, Lordship. But they have suppressed the fact so that I can be frame alone.
And what is the order passed in IA 17?
IA
This
17. Yes,
okay,
now 18, Lordship. Now IA 18, Lordship. IA 18, page number 196 of my affidavit, Lordship. I have enclosed the front and the back page. Lordship, yes.
So it's a very long order in IA 17.
Yes, Lordship, but this is the application wherein it says it's showing who has filed the IA. Who, through which council, Lordship? The council's name signatures are there. What is my signature? They have enclosed the IA. Is there any of my signature? They say that I have acted, impersonated them. My signature is nowhere because I have agreed. I still stand by the fact I have only agreed to enter appearance, argue the matter. Now IA 18 of?
Just a minute.
Yes, Lordship.
$17 is for what?
17 is for transfer of the baby to Ames Hospital, Lordship. Before all this this court was not inclined. IA 17 was filed.
By order dated 8/3, this one was dismissed. IA was dismissed.
Yes.
saying that it is not in accordance with the order passed. on
Lordship, yes. Lordship.
18.
So IA 18 has to be filed.
Where is that affidavit?
Lordship, order or?
Affidavit as well as the order.
Lordship, yes.
IA, where is that IA for removal? $17 is different.
17
is for direction to
transfer.
the state of Nagaland.
To
We
transfer
are
the
all
baby.
expenses. And direct aims to admit.
Lordship, yes.
That is 17.
Yes. So before IA 18 was heard, this court was not inclined to pass order in IA 17 because this court wants to make sure that all the prayers are deleted.
No, where is that? Where?
Lordship,
for
order
deletion?
deleted. It's page number 200, Lordship. This is the order, Lordship, where the court has allowed IA substituted the prayer as well as deleted, Lordship. Page number 200, Lordship. Heard Ms. Nitya Ghazal and the counsel for the applicant. So and so, by the instant application, the applicant have sought for modification of the reliefs sought for in a writ petition, whereby instead of the existing relief sought for in prayer number C, the applicant seeks substitution of the said prayer with the following. Pass an order directing the state of Nagaland through respondent number 2, 4, and 5 to shift the petitioner's daughter to the government hospital outside the state, which has the capacity to provide specialized care required by the applicant's petitioner's daughter and to bear all expenses associated thereof with her treatment as well as transportation. Apart from the above, The applicant also seeks deletion of the prayers so far as the prayer serial number D, E, and F are concerned. I have perused the application and the said application is in tune, Lordship. It says, I have perused the application and the said application is in tune with the submission of the learned counsel for the applicant as recorded in the order dated 18/2/2022. Now the court is satisfied. Accordingly, the relief sought for in the instant IA is allowed, thereby substituting the prayer C with the above quoted portion of the prayer and deleting the prayers D, E, and F in the instant writ petition. The registry is directed to make necessary correction in the writ petition in the manner observed herein above. IA stands disposed of. Now, only after this, Lordship, this court.
Where this IA 18? Where is it? Where is 18? Okay. Okay. So they have objection to this affidavit.
They have, Lordship. If they have objection, Lordship, there's a provision for them readily available to appeal, Lordship. Not to frame the counsels. Tomorrow, my learned,
Yes.
God forbid.
Where is that? Where is? Yes. What is his name? I forgot his name.
Sachin Jain advocate.
Sachin.
Yes.
Mr. Sachin,
Yes, madam.
we have seen the order 18/2/2022.
Yes.
Okay. So earlier, some one IA was filed. No, made a prayer in 16 or where, which was dismissed, saying that it is not in tune with the order dated 18/2/2022.
Your Honor, that
Just a minute.
that IA is after this order. IA 18 was filed in March, right?
Oh,
The
yeah.
order
Hmm.
is on February.
Which order?
Order 18/2/2022 is in February.
Yes, that is why I'm saying
Yes.
18/2/22 was filed, or the order was passed that was in the February, where she was not there.
She just admitted that she was there, Your Honor.
I did.
Maybe her admission would not do, because order reflect that two lady advocate appeared.
Yes, Your Honor.
She may be there, but because she was not advocate at that time, her submission also will not be recorded here, because it was the submission of the learned counsel who appeared on that day on your behalf.
Your Honor,
Okay,
I
just
have
a minute.
appeared in person.
18/2/22.
Yes.
And then that 16 was dismissed because on 18/2 it was said.
16 was filed in March 7, Your Honor.
No, wait. 16?
Was filed in March 7, more than a month after the order of 18/2/2022.
No, 18/2/22. The learned counsel, your counsel submitted that she is not pressing for relief.
Yes, Your Honor.
Sought for in the instant writ petition and would file appropriate application for deletion of the same. Okay?
Yes.
And based on this, the petitioner is bound to file application,
Yes, Your Honor.
isn't it?
We are not disputing that if the order
Yes.
gets passed, they have to file. What we're disputing is the fact that
Yes.
the prayers were removed by our council without our knowledge or consent.
Lords, can I respond to that?
Just a minute. And then thereafter, what was the petition that was dismissed as it was not in accordance with the order passed on? Stand dismissed, yes. And that was in 18-8. Sorry, 8-3.
8-3, Lordship, yes. 8-3,
8-3.
yes. Page number 177 of my affidavit, Lordship.
That is, after that, link is fixed. This is IA 15, sorry. It was 15.
16, Lordship. IA 16, Lordship.
It is 15.
15 is for the implement of Union of India. This has been allowed. 16 is
Stand disposed.
initial
Okay,
for deletion
sorry,
of
this
prayers.
is stand disposed. Those, that is 15 for implement. Okay. And then, yes, IA 16, sorry. This is 16. So 16 was dismissed, saying that appropriate deletion of the prayer as reflected in the order dated 18 to by this court.
Your Honor, if I can read you order 18.
Just a minute, let me clear that. You'll get opportunity, huh?
Sure, Your Honor.
If she is given 1 hour, you'll be given 2 hours. Just wait.
Obliged.
But I need to understand.
Yes.
Because there are a lot of orders.
Yes,
So
Your
many IAs have been filed. Yes, so the instant application may be permitted to be withdrawn with liberty to file an appropriate application for deletion of the prayer as deletion of the prayer. Because the court repeatedly insisted, because earlier by 18/2/2022, there was a prayer that you are not insisting. So that
Yes,
is why
that
this,
is the issue, Your Honor.
Yes, this 16, IS 16 was dismissed on withdrawn to file appropriate order
Yes.
for deletion of the prayer as reflected in the order dated 18.
Yes.
It's reiterating the order passed on 18 only.
Yes.
Okay. So this 18 on 18, sorry, on 8/3/2022, Nito Koja was there, but then she was insisted to stick with or to follow or to make a prayer as based on the 18/2/2022 where she was not there.
Yes.
Okay. And then thereafter, it appears that this 18 was filed. This 18 was filed on the insistence of the court to file in accordance with the order dated. Because once you have submitted that you are not pressing and you are once you are directed by the court to file deleting those prayer, there cannot any you cannot escape. You are bound to file. So based on that, she tried that. That was 16. That did not work. So it was filed by, this is 18. Okay. And on being filed, this court observed that this is in tune with the order passed on 2nd February. This is in tune with.
Lords, can I, before Ms. Barbara replies, can I respond to this query Your Lordship has said?
Just listen to me. This 18, what we could see is this order passed on 18, IA 18.
The 10th March order.
10 March.
Yes, ma'am.
Yes.
That's a short order.
Yeah, you are agreed by this.
Lords, we are not agreed by the order. We are agreed by the conduct.
Just a minute. But then whosoever may be, but then advocate, it appears, have done in accordance with the direction of the court.
This court.
On
No, I explain.
18/2/2022.
No, my lords, may I explain this?
Was not the
So
order of the
this-
court.
Can you see the order?
My lords, no, my lords, your lordship have seen the order. My lords, can I?
Can you see
Yes,
the
ma'am.
order?
Yes,
Paragraph
ma'am.
4. I have perused the said application. Okay.
Yes, my lords.
And the said application is in tune with the submission of the land council for the applicant as recorded in the order dated 18/2/2022. It is only reiteration of the 18/2/22.
Yes, my lords. Yes. How can I reply, my lords?
Court founds, court is satisfied, it appears, with the application filed by the applicant in 18/2022, because it is in tune with the order passed on 18/2/2022.
My lord, that was the order.
We should remember that on 18/2/2022, it was not C, the present petitioner, sorry, the present advocate who appeared, who made a submission. She continued with that direction, the submission made on 18/2/2022. So how do you clarify this?
Yes, ma'am. My lords, first of all, if the court was to remove the prayers, the court could have done that by a judicial order. The court did not have directed the parties.
Not only that, there was some direction also on 18/2/2022.
No, removal of the parties is one thing. We are not agreed with that. So there are two parts of 18th February order. One is the removal of the parties, which was done by the Honorable Court suo motu. And second was the deletion of the prayers, which was recorded at the instance of the councils then appearing for the petitioners.
Okay.
Now, thereafter, the petitioner did not make that statement, the council made that statement. Now, why the Honorable Court?
That we don't.
Correct. No.
We only believe that whenever the advocate, the council submits, we have no reason to disbelieve the council.
Absolutely. Absolutely.
Making such submission on being instructed by the client only.
Absolutely. I agree with that. Now, my lords, when advocates makes a statement and your lordship says, no, we want you to file an application with affidavit of the petitioner, then, my lord, it becomes important that the affidavit should be executed by the person who is authorized to execute it and not by somebody who forges somebody's signature and places it before them.
That is true.
Lordship,
So, my lords, just a moment. So, my lords, if Honorable Court has directed the council to file an application, it means your lordships wanted the petitioner to delete it, not merely by the statement made by the council. Now, the petitioner is not a willing party. She did not sign. So the council, for reasons best known to them, because it is a matter of inquiry, as your lordship rightly mentioned, that she forged the signatures and presented that application and got the prayers deleted to my prejudice. Now it takes away all my rights in my petition.
Just you have to clarify. Are you agreed by the order 18/2/2022? Agreed by the person who signed?
Lords, let me explain that. Lords, 18th February order records that the council will move an application. Right. So the council is supposed to move my application on my signatures. My means the petitioner's signature. The petitioner will sign the application and they will sign the affidavit also. Now they don't do that. Maybe they don't agree. They want to contest. If they want to contest, the judicial orders can be there to remove those prayers. That does not happen. The council, one of the councils.
Your Honor, if I may please.
No.
Just a moment, Ms. Barbara. Lord, the council moves an application supported by an affidavit. I can understand the council could have filed her own affidavit saying that, look, these are the directions and I want to remove it. No, but she forged my signatures. She forged the signatures of the petitioner and then filed that application. And there is an order, then judicial order passed on that application. Now, the question before the Honorable Court is whether I have executed that the signatures on the affidavit or not. I am saying I have not done that.
Let us be clear. You are agreed by what?
My lords, I am agreed by the application moved by Ms. Koza on basis of an affidavit which I have not signed.
Where is the
This
proof?
is one thing.
Where
This
is
is
the
one
proof?
thing.
Just a minute.
No, I'm showing everything, my lords. And secondly, my lords,
So
the
just a minute. The court has directed on 18 on submission of the Land Council on 18/2/2022.
yes, my lord.
And thereafter, the Land Council has filed application based on that.
IA 16.
IA 16. And
Yes,
this,
ma'am.
that was dismissed because it was not in tune with the order dated 18/2/2022. What alternative, according to you, the Land Council have? And,
My lords, the alternative is this,
Thereafter,
that the
thereafter.
learned council would have
can,
apprised the court.
can the council or the petitioner escape without filing application if the court insists?
My lords, can I just reply? My lords, if that happens, yes, my lords, the council would ask the petitioner to come and sign. If they refuse, then it is the duty of the council to inform the court that the petitioner has refused. Now, thereafter, the court can pass any judicial order.
Different issue. That is different issue because they have the sign.
Afterthought.
Just a minute. That is a question a disputed question because who signed we do not know because it was signed before the notary. It was and then the petitioner admitted that he has signed some around 16, 18 some signature, and then he also doesn't remember that. And then you see thereafter, my question is that the petitioner in 16 was dismissed, saying that it was not in tune with order dated 18/2/2022. What alternative the council or the petitioner have other than filing?
May I answer that?
No, my lords, they have the alternative of not filing it. My lords, can I just complete it for a moment?
Please.
They have the option of not filing.
Answer me. Just answer me.
They have the option of not filing it and apprising the court that the petitioner do not want to file it. Let judicial order be passed. Thereafter,
order is already there. 18/2.
No, 18/2 order is records their submission. It is not a judicial order. It is not the mind of the judicial officer. It is the order recording their submission. Now, if the council make a submission,
You mean to say that the Land Council can refuse to file affidavit despite of court direction?
Lords, he can file an affidavit, but that affidavit should belong to me, or he can tell the court that the petitioner is not agreeable.
Signing part is again disputed fact that we are not on that. How you are aggrieved by this?
Lords,
signing part.
Yes,
Because
my lords.
How you are aggrieved otherwise?
Lords, I am aggrieved by
filing.
Yes, ma'am.
Let us assume that it was filed by the petitioner.
Lords, if we assume that, then nothing remains. If your lordship will assume that she has signed it, filed it, then nothing remains to be said.
Okay. Under the circumstances, what would you say that there was no any instruction for filing? What would be the instruction of the petitioner then, under the circumstances?
My lord, she could have said that let the judicial order be passed. If the honorable court feels that no, my lord.
Some advocate may, of course, make that submission, but then you cannot expect from all advocate that when the court insists to file affidavit because you have undertaken to file, you have undertaken that you have made that prayer and you file. Before filing, you cannot.
Both things. Neither of the things have been done by me. Please appreciate. Please appreciate.
Yes, there is a possibility that some advocate may not, of course, resist the court's insistence, isn't it? If if you agree with that, then what option he has or she has?
She has the option to, my lords, like initially she said, I did not want to continue, so I removed my name. Lord, she could very well take a stand that the council on record.
What's the read petition? That was the main petition, not the IA.
Lord, she says, my lords will see her reply. She says that she removed.
She was made to withdraw. And it was not in tune with.
Your Honor, she wasn't made to withdraw. Read Order 18/2/2022. Nobody was made to withdraw from the petitioner's side. The petitioner's counsel is the one that requested to withdraw the prayers.
8/3/2022.
18/2/2022. That's how all of this started. You've asked
83.
Yes, that's
18.
Your Honor. You're saying, let me answer your question, please, Your Honor, if I may.
Yes, please.
You questioned that according to the order passed, the advocate had no choice but to file the IA for removal of the prayers. What else could she do since the order has been passed by the court? Yes, that is true if an order is passed by the court, but why did the court pass that order? The court passed that order because of
challenge.
because of
There is a
yes, but how can the petitioner challenge something that the petitioner has no knowledge of? No knowledge or consent was given.
That again, you say, that no knowledge part, that is disputed fact. And if you insist, you can file.
The petitioner didn't
that
know of the fact
requiring-
until 2023, Your Honor. So how can the petitioner, and being the counsel, she should inform the counsel, the
Anyway,
petitioner.
anything to submit, Mr.
Lordship.
Lords, can I just show the para 40, just two paragraphs from her reply, from a counter affidavit. Please
Okay.
have,
Just a
please
minute.
have,
You are represented by the Land Council. Please take seat.
Yes.
Okay. Take seat. Take your seat. Yes, please.
please have, my lords.
Hmm.
My lords, the
Page?
your lordship can have page 30 of her counter affidavit.
$30.
30, para 23.
Affidavit in opposition.
Affidavit in opposition, madam.
Okay. 30. Yes.
Your lordship will see para 23, my lords.
Yes.
Lords, can I read it from here, my lords?
Please.
Lords, before countering paragraph 13, 14, and 15 of the complaint, it is relevant to bring to before the notice of this court the facts surrounding the understanding and agreement taken place between the respondent, her colleagues, and the applicants. Initially, the respondent was assisting with logistic support to the applicant number 2 in writ petition civil number 6 of 2022 and her colleagues in HRLN Delhi office in good faith. Before the petition was filed, respondent received a call from applicant number 2, who then told her that there will be a conflict of interest if she appears in her husband's case. Respondent was taken aback, hearing about that she is not related to the applicants in any manner. Applicant number 2 was beaten around the bush by the then respondent, knew that she and her husband does not want to appear in their case, so she asked her to come to the point. Thereafter, applicant number 2 said that her godfather and one of the respondent's sister, godmother, are related, so there will be a conflict of interest. Respondent was perplexed because her family is very close-knitted and everyone knows everything about each other. Respondent knew that her sister, whom applicant number 2 is referring to, is a well known in the society, being a leader in the church. She is loved and revered by many, so naturally she knows many people and many people knows her. Upon inquiry, the respondent came to know that what applicant number 2 said was not true, as her sister does not have any godmother. Reading between the lines of the applicant's comment, respondent informed one of her supervisor, who was kind enough to relay the message to the founder of HRLN. And finally, respondent was relieved from the case of the applicant. Now, this is important. Please mark this, my lords. Thereafter, before filing the petition, respondent instructed her colleagues to strike off her name from the wakalatnama since the client does not want her in their case. So they did, and while doing so, they also struck their names off from the same, and the petition was subsequently filed. Registry was kind enough to accept the petition, considering the urgency of the case. This is also evident from the court record, which respondent obtained through the registry. The office noting maintained by the registry giving remark of the petition after filing also does not reflect respondent's name. Filing form which is filed along with the petition also does not bear the name or traces of the record of the respondent, which is proof that the respondent did not tamper with the court document. Copy of the registry is so and so. So, my lords, what is being happening? No, the respondent number 7, she is saying that before filing the case, she is filing the case and removed all the names. So there was no filing advocate. And just on the asking of the registry, she mentioned the name of one lawyer from Delhi whose name is Mugda. And at the place of signatures, her name is mentioned as if it was her signatures, which she has denied that these are not my signatures. The Lordship will see, Lords,
Lordship, I have already given the. They are making baseless allegation without any proof. I have submitted my evidence, Lordship.
Let him complete.
Lords, we'll have now para 42, my lords, at page 44.
Para 40.
Para 42 at page 44.
Yes.
Lords, she is saying that the respondent vehemently denies the allegation made by the complainant in paragraph number 13, 14, and 15 of the application. As seen in the above paragraphs with evidence, the present respondent did not forge signature of the applicant, neither did she tamper court wakalatnama. Applicant number 2 was actively participating in the entire process of proceeding, and the IA 15, 16, 17, 18, 20 of 2022 in connection with writ petition number 6 of 22, and the IA which were all filed with the consent and knowledge of the applicant. So, my lord, they have been filing the applications. I wanted to show this thing. The advocate, respondent number 7, was filing these applications before this honorable court, which she says allegedly with the consent of the petitioner. No, please have further, my lords. Lords, please have para 45. This is at page 47.
Yes.
It is relevant to bring it to the notice of this court that respondent was not the one drafting or filing the IAs which the applicants are alleging. Her name was used. Now, this is important. Please see. Her name was used in all the IAs without her knowledge. Now, please, my lord, see if she is filing the IAs, who was using her name is a very important thing, which now she is saying on affidavit. I am repeating this line number 3, my lords. Her name was used in all the IAs. Your lordship have that, my lords? Without her
charges.
It's alleging.
I am not pressing any charges.
No. Her name was used in all the IAs without her knowledge and consent by the person drafting the IA. No, she is saying.
It does not bear my signature.
No, please see. She is saying that her name is.
The air without any proof.
Lords, I'm just reading her own
Without
affidavit.
any proof, Lordship. Lordship.
Yes.
Lords. And then she said, the signatures contained in the IA number 15 of 2022, 16, 17, 18, and 20 of 2022 in connection with the petition civil number 6 of 22 are also not hers. Now she is denying her own thing also.
Yes, that is the truth.
Should the respondent sue or demand criminal action against their colleagues? Now she is putting the onus on the colleagues and the applicant for using her name and copying her signatures. Now her signatures are copied, she is saying, my lords, or even made an issue out of it when it was all executed in good faith, or to save the life of the daughter of the applicant who was and is battling for life in the pediatric intensive care unit at CHSR. Suppose if the signature of the applicant number 1 is forged, was it done to commit an offense? My lords, what kind of affidavit is this? Well, she is putting a question that even if it is done, it was done in good faith. Well, it's forgery, clear forgery on the records of this honorable court.
Lordship, kindly allow me.
The answer is no. If at all the allegation
Let me
against is
hear me now,
true,
Lordship.
Yes,
Let
it
us
will
go
not.
straight to the
It
point,
will,
Lordship.
ma'am, just a minute. I am reading your affidavit only. The answer is no. If at all the allegation against is true, still it will not attract section 463. Well, this kind of affidavit a lawyer is filing in the High Court. Now, please have. Now, please have para 46 also, my lords. Now, this will end everything. Para 46 is at page 49, my lords.
Yes.
With regard to the statement made in paragraph 16, your lordship have got it?
Yes.
The pairs which were deleted and substituted through IA 18 of 2022 was done at the instance of this court, which was reaffirmed by this court during the court proceedings. Sorry, my lords. Sorry, I was to read para 49 at page 51. Page 51, para 49.
Yes.
The law is settled. The law is settled and is amply clear under section 89 of the Indian Penal Code that acts done in good faith for the benefit of child or insane person under the age of 12 years is not an offense. Now she is trying to defend herself on the ground that she is protected by section 89. Further, section 92 of the Indian Penal Code states that nothing is an offense for act done in good faith for the benefit of the person even without consent. My lords, what more is required? Moreover, advocate, once instructed to represent the client, has authority to do such acts for protecting the interest of the principal. Lords, nothing remains. Now she has come on 89 and 92. Are they meant to forge somebody's signature? And Wakalatnama, my lords, the lawyer in Delhi is saying, I have not signed this Wakalatnama, and she has signed it. And now she is saying, no, these are not signature. I have just mentioned her name. My lords, who will mention the name at the place of signatures? Lords, I think, my lords, this matter, your lordship rightly observed, requires an inquiry. My lords, can.
Yes, what we can do is we have Samara matter also.
Yes, my lord.
Is
lords, yes.
I'll keep it as a part hard to be concluded in the next week.
Yes, ma'am. Yes.
Whether this was admitted?
Yes, my lords. The IA 61, yes, my lords.
It's pending, Lordship. It's not admitted. Only I've been made a party.
No, admitted means
file objection, Lordship. File objection.
My lord.
Lordship, yes, the matter will be heard next week, he said. I agree, Lordship. Lordship, however, the truth of the matter is that whether their allegation fulfills the ingredients given under section 463, Lordship. Well, how? How did
Lords
they?
can have it on 9th, my lords.
This Lordship has understood. Every action, every IAs were modified as per this court at the instance of this court's order, Lordship. These are judicial orders. Now I have enclosed all the proof wherein the petitioners have knowledge, Lordship, and they have instructed. Now they're acting as if they don't know. They are so smart. They were appearing in person themselves, Lordship. In fact, this IA was filed by themselves. Lordship, also kindly note the fact that whether 463 is attracted here, Lordship. There is also general exception, which my learned friend has also pointed out. Section 89 of IPC, 92 of IPC, Lordship. When no crime is committed, under what law will I be punished?
This is item?
That's item 21.
Okay, 21. Okay. No, 21. This is IA. In IA 65, we have passed order. No, not. In which IA we have passed order?
Lords, IE 21, your lordship was hearing in the morning.
Year 21 of 25.
21 we have passed. Okay. So, then IA 21, IA 65. Okay. Hmm. Hmm. Okay. Their pleadings are completed, isn't it?
Lordship, yes.
Okay. The same. Have you recorded 21 also? You have recorded.
Yes.
Okay, council same. Okay. The line council for the party submits that pleadings are completed. Hmm. This 22 is but okay. Completed, huh? List this matter again the next week, huh? For hearing. Okay. Okay.
Lordship, on 10, 11, I'll be out of station, Lordship. 10, 11 till 14.
Lords can keep it on 9th also.
9 is hearing day. Cannot.
16 minutes.
The 9 is DVs. No?
Yes, Lordship.
Okay.
8.
Hmm?
8, Lordship. If it's convenient for your Lordship. 8 is Tuesday, Lordship.
8.
Lords, 8, I may be traveling. Otherwise, there's no problem.
Otherwise, 7 is also available, Lordship. Monday.
Lord 7, I have many matters in Lord's Delhi.
Then
Lords can have it 9th. It doesn't suit your lordship. Your lordship can have it on 11th, my lords.
no, 9 is a DV day. We don't-
11th, my lords.
11 is a Friday. No, last day.
Lords.
10 can be 9 or 10.
Lords, 10th is a holiday, I think.
I'm traveling on 10.
Then it will go next week.
Okay.
Thereafter. Then automatically it will go to 14, 15, and 16.
Lords can have it on 16th in that case, my lords.
I'm agreeable.
It is Wednesday again, Lordship.
16 is Wednesday.
Yes.
15.
15th is, yes, my lords, 15th.
Lordship.
Okay, let's pray for by the both the council for the party. This one again on 15. Okay.
Grateful, my lords.
Obliged, Lordship.
Mm.
Thank you.
For admission, item number 16.
Item. Okay.
I was informed that they executed the one, Your Lordship. They executed.
Executed.
Yes.
Then you say unless the bail granted to the accused is cancelled, it will be difficult.
No, Your Lordship, here, what I am informed is that, Your Lordship, the interim bail was granted for 15 days, Your Lordship. Was granted.
Now whether the surety or any deposit,
No.
no deposit,
Surety in the form of a local person who is a regular government servant.
not deposited anything.
No
any
cash,
amount.
no cash surety.
So that means you mean to say it's automatically it expires.
Yes, because the district and session judge rejected the regularization, Your Lordship, of the anticipatory bill. The pre-arrest bail was granted only for 15 days. It expired on 26. However, on 26, Your Lordship, the matter could not be taken up because the PP was.
Okay, so what we can do is at the moment, so protection can be given. He will cooperate. He will cooperate.
Yes, Your Lordship, my objection may be recorded, Your Lordship. Now, what the IO has stated is that, Your Lordship, she has been receiving harassment calls, Your Lordship, that you are not the competent person to give me, to call me like this. You have, I mean, someone has to do given, something like that. I mean,
If that be so, will not regularize.
So that is the difficulty.
So that
she
condition
has
will
expressed.
put.
That is the difficulty she has expressed. So you Lordship, if this honorable court so
Okay.
deems that distributor should be given the strict compliance, Your Lordship.
Okay.
Condition should be laid on the Lordship.
Okay, hard, Mr.
Zakato Chishi. Your Lordship, my submission may be heard, Your Lordship. My submission may be heard, Your Lordship. I may be
Counsel for the petitioner. Also hard. Ms. Libika, learned additional PP.
PP.
Oh, sorry, PP, learned PP for the state of Nagaland staff. This is the petitioner files application under section 482 of BNS, praying for grant of pre-arrest bail, apprehending his arrest in cases not yet been charge sheeted.
No.
Okay,
It's still
apprehending
investigation.
his arrest in connection with
It's a family related.
Dimapur Women PS case number 82 within bracket 1/85/351/2 read with section 4 of Dowry Prohibition Act. Start. Para.
Your Lordship, the relevant portion of the IO report of the IO may be recorded, Your Lordship. If this
Where is the relevant portion?
I have given on the loose sheet, Your Lordship.
Okay.
The relevant para will be the Lordship. Second page,
Of
third para, Your Lordship, on 22 to.
third para of submission of inquiry report.
Oh, yeah, inquiry report, and as well as the last para, Your Lordship. That will be relevant.
Third para and last para.
Yeah, last.
What the third para says?
Para, Your Lordship, about how she has received the harassment calls and as well as like as to why, Your Lordship. And the last para, Your Lordship.
Last para.
Yes. Considering this fact, Your Lordship, it is honorable Dean Street and Your Lordship, I will give the.
Where is the last para?
Last para, it is to mention that investigation is still in process and the accused and his family are not cooperating with the investigating agency, and if his bail is regularized, then he will surely give them up.
No, this is not regularization. Whether have we granted any interim?
No.
Not yet, not yet.
Okay,
That period
this
has,
actually, Your Lordship.
it was filed on
So
13th.
this probably was before the.
Yes.
Yes, Your Lordship.
And because of this, the interim was rejected, Your Lordship. And now the petitioner coming before this court with a new disputed, Your Lordship.
Okay.
Your Lordship,
Basically,
this,
it was rejected, Your Lordship, on the day 2010.
when an application was filed before the learned sessions court, interim was granted. Thereafter, it was not regularized.
No. So that is why it was probably rejected.
Yes, and we filed before this honorable court on 13th February 2025, where I sought for interim prayer, but this honorable court was under the impression,
Because of that allegation.
under the impression that since he has been granted bail, so interim is not required. That was the impression by this honorable court.
No, but but now says say that the bail granted to you expired, and then subsequently it was not regularized, and your bail dismissed
Yes, Your Lordship. That is why
on the allegation that there is you
on
threatened.
two allegations, Your Lordship. One is non-cooperation, and one is that a threat has been extended to the IO through a third person.
Right,
That is the
right.
allegation, Your Lordship.
Now,
So,
under the circumstances, how do we protect?
Your Lordship,
Under the circumstances, if there is a threat, how do we protect? And then the trial court has rejected your bail, anticipated bail.
yes, that is the reason why this
And
application is.
on the same ground, how do we grant? The same report is coming from the IO of the case. Same report.
Your Lordship, whether there are materials to show that it was the petitioner who has extended the threat, or is there any connection?
No, the IO says.
Your Lordship,
It
just
is IO who is saying, it is the IO who is investigating the
Lordship,
case.
it's not that
Who
the
is
mere-
saying now? How do we display?
Your Lordship, the mere submission given by the IO cannot be a gospel truth, Your
Then
Your Lordship.
who will submit in the case?
There should be a
Who will
record.
give a fact
There
of the
should be
case then?
documents, Your Lordship.
Who?
There should be documents to substantiate that.
What kind of
allegation.
document? The IO says,
Whether
on
that-
investigation, IO has found out that he is threatening. What document? Threatening,
Your
verbal
Lordship,
document?
the petitioner has been complying to the orders passed by the Honorable Learned Sessions Court during the interim period. He has complied by coming before the IO on 17, 18, 22, and on 22 formal arrest was conducted, and 28 the application was heard, and on the adverse report given by the IO the application was rejected. However, the allegation is that
His statement probably was recorded.
it was recorded,
his-
Your Lordship,
his
not only
statement-
the petitioner but the family of the petitioners also.
She is recorded, but there is an allegation that.
And then
was
the,
already-
when this FIR was filed,
FIR was filed on the 5 February 2024, Your Lordship. Your Lordship, I may be
now,
allowed to
if,
make my
if
comment.
the investigation is going to be completed,
Your Lordship, it's not.
why he is not submitting any charge sheet then?
No, no, it is not completed, Your Lordship. There's already.
Because
allegation that-
all the family members have been, you have said, just said.
Your Lordship, it seems that the petitioner has already remarried, Your Lordship, and
That is the
they
allegation, Your
are
Lordship.
locating the new, the wife, the newly married, I mean, the second wife, Your Lordship. Because the divorce petition has not been completed as per the record, Your Lordship. The divorce proceeding is not completed, and during the divorce proceeding only, Your Lordship, the petitioner has already been married. And there's a photograph also, Your Lordship.
But
So-
now you see, after vacation of the earlier interim bail granted to the petitioner, what prevent the IO to arrest him?
No, Your Lordship, the petition came before this, honorable
No,
court.
there is no protection.
Yes, Your Lord, that's why the opportunity came before this court. Your Lord.
No, that is why before this court they came,
Yes, sir.
the court having observed that he is not entitled for the interim bail. That
There
is
was
why.
no impression
Just a
during
minute,
that time,
just a
Your
minute.
Lordship.
Yes,
It was not granted.
Yes, Your Lord, to that regard.
So he was not protected by any law, any
Yes.
order of the court.
Yes, Your Lordship.
What prevent the IO to arrest him?
Yes, to that regard, Your Lordship, I inquire, Your Lordship, because on that day, when they dispute.
No, till now,
That's
till
why,
now,
Your Lordship-
when it was filed, it was filed long way back in 12/3.
Yes, Your Lordship, that's why I'm making a submission, Your Lordship.
Hmm.
When the dispute bill was filed, I make an inquiry, like I called up the IO of the case and inquire as to why she has not made any arrest. It seems that like because of her sister's wedding, she was out of station, and that's why that could not be executed. That is what
Whose
I-
sister?
IO.
IO is out of
Yes,
station.
that's why she was out of
Now,
station.
now she is there.
Yes, she reached, last time, only, Your Lordship, I received this thing report, all this reports, Your Lordship. Only after reaching, she sent me this one, Your Lordship. And she could not able to come personally also, and everything.
And then
she sent it through WhatsApp,
you
Your
see, the bail was rejected.
Yes, Your
Earlier
Lordship.
bail was rejected when it was done. Mr. Application, it was dismissed on, see, 28/2, way back in 28/2. Now it's more than one month.
Yes.
She was out of the station since 28.
Your Lordship, on 28, it was rejected, Your Lordship. After that, it seemed that she was out of station, Your Lordship.
From 28 to till yesterday, she was out of station. What a coincidence.
Your Lordship,
Hmm.
it's the report, but still, I mean, like, I don't know how.
Your Lordship, if I may be allowed to submit on that point, Your Lordship.
Just a minute.
To
Yes.
explain the position, Your Lordship.
What
Question.
position?
Your Lordship, when this application was filed on 13/2/2024, before this honorable court,
Hmm.
Your Lordship was hearing this matter
Hmm.
at the stage of motion. And
No
I had-
interim was granted.
Yes, I had submitted that there is an interim period, but the Lordship was under the impression that since he has already been arrested and bail has been granted already, so there is no requirement for interim period. That was the impression of this honorable court. If
I didn't
my
know.
learned friend-
Now she has made clarify.
If my learned
She has
friend-
clarified that it was already dismissed and due to the expiry of it was granted till 16.
It was supposed to be fixed
16.
on Monday, but since on unavailability and Lordship inconvenience of the petition also, the matter was fixed on 1st April, today, Lordship. And meantime, when I.
No,
inquired
the
from
court did not
IO
pass any order. Court did not pass any interim order.
Yes.
Did not pass.
Court only observed
Yes.
that if you say that bail was granted, you were arrested, then only the court says, if you were arrested, then unless the bail is, unless the said bail granted to you is cancelled, then you cannot be arrested. Otherwise, you are protected, already protected. No interim order was required.
Yes, your
I
lordship.
was under that impression.
Yes,
But now
yes.
it is clarified that it was only for limited period,
Yes, we
on
will.
expiry of the period, and you also did not execute a bail bond by depositing amounts, etc.
No
No.
cash surety was deposited.
No,
but surety in the form of a government servant or local person was submitted to the police station.
But then
in
if
compliance, your lordship.
if it
But-
was for the limited period,
Yes,
it expired
I
with the
agree, your
expiry of
lordship.
that date.
That was submitted before this honorable court in the last occasion at the stage
Ah.
of motion.
No, I thought that
But-
you said that bail was also executed. I-
That
I had
was
some
earlier,
different-
earlier, your lordship. That was earlier, not before this honorable court.
Anyway,
Before the matter was moved
anyway,
before this honorable
now also, what we can do is now also, if it is clarified, that because it is still under investigation.
It's none.
And you said that he has remarried before the divorce proceeding
As per
with the
the-
first wife is completed.
Yes.
And there also probably some section will attract against him. So let him carry out the investigation and submit the.
Yes, your lordship, that can be, but
But till then, he can be protected.
Yes, but your lordship, let that be a condition.
Yes.
Suppose your lordship,
Yes.
there is a harassment call for, to the Aya, your lordship,
Okay.
because it is, the Aya is personally informed me that
okay.
she has been receiving threatening
I can
calls.
assure
The
that
Lanet
that will not happen,
people,
lordship.
the Lanet people submits that the case is still under investigation. Still under active investigation. And since there is an allegation against accused that he is not cooperating with the IO of the case. Therefore, she has an objection to the grant of interim protection to the petitioner. Stop. Be that as it may, since the case is still under investigation, and on record it appears that the accused applicant has cooperated with the IO of the case by appearing before him for about 3 times. I'm of the opinion that the accused can be extended with the interim protection. Stop. Accordingly, the least this matter. The least this matter after 3 weeks, probably 4 weeks, 3 weeks. Least this matter after 3 weeks. On which date the entire CD will be produced. Okay, the updated CD will be produced. Stop. Till then, in the event of the accused, what is his name? Lalit Prasad. Lalit Prasad is arrested in connection with the Dimapur women PS case number 8201/85/351 within bracket 2 read with section 4 of the Prohibition Act, he shall be released on interim anticipatory bail on execution of a bail bond of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority with the following condition, on the following condition, start, that the accused shall not shall cooperate and appear before the eye of the case, as and when called for, that he shall not directly or indirectly, make any inducement, threat or promise to any person acquainted with the fact of the case, including the informant and our family members, so as to dissuade him her from disclosing such facts to the court or any police officers. So, I think that is enough.
Yes, Your Lordship, and in the event, Your Lordship, this has not been complied, and Your
Okay.
Lordship.
It is made clear that
It will be automatic.
in case of violation of any of the above condition, come the interim anticipated bail granted to the accused. Now, can we give that?
Your Lordship,
Shall
Your
stand.
Lordship,
Shall stand cancel on application made by the PP. Okay, that will do. Okay. List is matter. Okay, anything else? Okay, please.
For hearing, item number 29.
This is hearing. Oh, then it will be hearing will not be able to today, it appears. Okay, due to paucity of time, the hearing could not be taken place. Accordingly, the matter stand adjourned. We are in this item 29.
Yes, Your Lordship.
Okay. So when?
Thursday, Your Lordship.
Thursday, I think the morning we have fixed Marameter again. What is this matter about otherwise?
For squashing of the criminal complaint as well as order passed by the court, Your Lordship.
Or passed by the session court?
Yes.
Okay. Wednesday is not possible.
Not possible, Your Lordship.
Then Tuesday?
Lordship.
Tuesday will
That
come.
is, Your Lordship.
Okay. On Tuesday, huh? Tuesday. Okay. That's all. In the earlier case?